Right. Am I on here? Is this working? Okay. Former Attorney General Ramsey Clark has agreed to say hello to the group and extend his best wishes and greetings. I go back a long way with Ramsey, sometimes on different sides of issues, but since 1969, when he left the Attorney General's office, he has devoted so much of his time to human rights issues and cases here and around the world. He has run the risk and the danger of going against two heads of state at a critical time and suffering Rule 11 sanctions as a result of it. So Ramsey has been a remarkable fighter for human rights since he left. He inspired me to become Zulfikar Ali Bhutto's last lawyer on appeal when he was former Prime Minister of Pakistan. And when I was negotiating the appeal with the Chief Justice of the Supreme Court, the Zia-ul-Haq took my client out and hung him. Not one of my more happy moments, I have to say, although it led to other work that I did to get his daughter, Bibi, released from house arrest. But Ramsey was the inspiration for that and some other human rights work that I did. I believe Ramsey's ready to come on now, is he? Okay. Ladies and gentlemen, Ramsey Clark.
Called by me in the past for institute, and known his greatest love and affection for the memory of Abraham Lincoln's great speech there. But he ended with a line all people should know and remember, which went, "Let us have faith that right makes might, and in that faith, let us to the end dare to do our duty as we understand it." In that spirit, welcome to Cooper Institute or Cooper Union, a historic and beautiful place on a beautiful Sunday in Manhattan. And wish I could be with you.
Thank you, Mr. Clark. Wayne, is there more? No. So that's all we have from General Clark. We were lucky to get him on the phone. We couldn't get him on Skype. Long story, but it's an honor to have him give us his moral support. Well, his focus was on the historic nature of the Cooper Union and Abraham Lincoln speech, and I think he was analogizing our effort to some of Mr. Lincoln's work, but that's the best I can tell you.
Yeah.
We are ready to go. Sorry.
He's not been well, and that's why he's not here in person. But he wanted to say something to you all and to wish you well and do his best under the circumstances. Okay. Thank you, Mick. All right, let's move on, shall we? Graeme McQueen. Graeme was born in Nova Scotia, a Buddhist scholar, retired professor of religious studies at McMaster University in Hamilton, Ontario. He taught there from 1974 to 2003. He was the founder and former director of the Center for Peace Studies at McMaster, and in 2014 he authored 2001, The Anthrax Deception, the Case for a Domestic Conspiracy. Now, Professor McQueen presents a summary of oral testimony from first responders to the lawyers panel for evaluation. as to whether this evidence corroborates the scientific evidence presented in the prior session and adds weight to a petition for a grand jury or potential future civil litigation. That's going to be for the lawyers panel to evaluate. So without further ado, Graeme, we're waiting for you. Thank you very much.
Can you hear me? Okay, thank you. It's an honor to be here and to address you and to join with my colleagues of this morning to present evidence relevant to an extraordinarily serious crime that happened 15 years ago in this city. The focus of my talk will be on eyewitness evidence bearing on the explosive destruction of two buildings, the Twin Towers. I should say that I've spent years now trying to figure out what happened on that day, 9/11. Broadly speaking, that's historical research, and I feel confident in its quality. However, historical research and research that is legally useful are two separate categories, and I'm happy to leave it to this panel to kind of translate what I'm giving and what people this morning gave into categories that you can use. I may make brief reference to some of that, but it's certainly not my area of expertise. I have one more comment to make in an introductory way before getting into the meat of it, and that is that we should think about the framing of this whole event. Frequently, people suggest that it's obvious that these buildings came down because planes hit them and damaged them, and that was the original hypothesis. It's the natural hypothesis, and that people like me came slouching along after the event with our paranoid fantasies and conspiracy theories. We are revisionists. We are trying to change the original truth, and that is historically false. Right after the destruction of the first building on 9/11, both hypotheses that are being debated today were expressed, they were articulated, they were put forth. And neither one has priority in terms of time. The explosive demolition hypothesis was found all over the place on 9/11. It was found on mainstream news, for example, and here's one brief example.
We are also waiting for a statement out of the European Union. We had been told that EU would be issuing a statement shortly, and we will get back to you when we have that. Back to you, Mark.
We have an enormous explosion now in the remaining World Trade Tower Center. The second, I believe the North Tower is now gone as well.
Right. Now, I didn't give that to prove that the buildings were explosively destroyed. I simply gave it to illustrate to you that this was common fare in the media on 9/11, and we should remember that. How about on the scene? You know, people who are actually there, who are participating. Here are two quotes. First, firefighter Christopher Fenyo, directly after the destruction of the South Tower, he said, quote, "A debate began to rage because the perception was that the building looked like it had been taken out with charges." Firefighters at the World Trade Center were debating that right after the destruction of the first tower. Even more strongly, FDN Fire Marshal John Coyle said, everybody, I think, at that point, still thought these things were blown up. Okay? So my point is clear. It was an original hypothesis. We need no apologies for pursuing it. Our task is to choose between these two hypotheses, which have raged since the morning of 9/11. Structural failure because of plane damage and planned demolition. And now let us begin to look at what an explosion witness might look like. I'm going to begin with a man named Paul Lemos, a New Yorker. who was at the scene on 9/11 and who witnessed the destruction of the Twin Towers.
Can you tell us your name?
My name's Paul Lemos. All of a sudden I looked up and about 20 stories below, that's what it looked like to me, about 75 flights up, below the fire, I saw from the corner, boom, 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 boom. Just like 20 straight hits. Just went down, and then I just saw the whole building just went, oh, and as the bombs were going, people just started running, and I sat there and watched a few of them explode, and then I just turned around, and I just started running for my life, because at that point, World Trade Center was coming right down, right above us.
In case you missed some of his very important words, here they are. All of a sudden, I looked up, and about 20 stories below the fire, I saw from the corner, boom, 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 just like 20 straight hits just went down, and then I just saw the whole building went, and as the bombs, crucial word, were going, people just started running, and I sat there and watched a few of them explode, and then I just turned around, and so on. Now, when we get testimony like this, or if you prefer a statement like this from a witness, what do we do with it? First of all, let me ask the question, where did this come from? Did this just float in anonymously on the internet? This is important if we're judging the quality of this evidence. No, it did not float in. I'll tell you how we got it. Attorney James Gorley in 2010 submitted a Freedom of Information Act request to NIST, attempting to get all the videos and films they used as part of their investigation of the destruction of the World Trade Center. And they ignored him. And he went back after them, and they ignored him. And this went on for months, so he finally filed a lawsuit in federal court. And there may be a lesson here for us about the usefulness of legal strategies, because he then got a wealth of information. And this interview, which you've just seen a small excerpt from, it's very rich, was part of that material. So that's how we got it. The other question we'd want to ask is, what's at stake here? Why is this important? Well, if what this man says he perceived, he truly perceived, then the whole official story of 9/11 that we've been given is false. The official story, just to remind you, has no room for explosions. They play no significant role in any of the official accounts of the destruction of these towers. And this man says he saw what he calls bombs. Let us interpret that as explosives, moving systematically and regularly and tearing the building apart. Now, if we were sincere investigators and we wanted to follow up on this, what would we do? There are a number of things we could do, but two of them would be, first of all, to seek corroborating evidence. Is there confirmation, both from other eyewitnesses and from non-eyewitness sources, such as you've seen earlier today? We would also want to look for disconfirming evidence. We want a hypothesis that can stand up to criticism. So if people have other explanations for what this man says he perceived, we would certainly want to look at those. Now, my time is not too long, but it's long enough to give you, I hope, at least a taste of what it would look like to follow those two routes. First of all, is there anything then that tends to corroborate? And I'm sticking to eyewitness. What are we doing? Sorry, I'm sticking to eyewitness evidence since the other evidence has already been covered. Here are two firefighters interviewed very shortly after the destruction of the towers, and I suggest they corroborate what Lemos said.
Nobody yet. Where the fuck? What are we doing? We made it outside. We made it about a block.
We made it at least two blocks, and we started running. Floor by floor, it started popping out.
It was if they had detonated.
Yeah,
detonated. They were planned to take down a building. Boom, 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 boom.
All the way down. I was watching it and running. Just ran up, and then you just saw this cloud of shit chasing you down.
Okay, the crucial words, again, just to make sure we're all on the same page. One man moving his hand, floor by floor, it started popping out. Tardio then moves his hand. It was as if they had been detonated, you know, as if they were planted to take down a building. Boom, 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 boom. And the other man confirms it. Now, quite apart from the words they use, it's astonishing that these two independent pieces of film show men using exactly the same gestures, all three of them. And these gestures are clearly meant to indicate that they perceive distinct impulsive events at regular intervals, moving down the buildings and tearing them apart. So I consider that strong corroboration. I consider these very rich statements. Now, you may be thinking that's all well and good, but this is 3 eyewitnesses. Is that all you got? It isn't all we've got. But if you were to ask me how many eyewitnesses there are who perceived or thought they perceived explosions, I would have to say, who knows? As far as I know, the FBI never made an attempt to do a comprehensive set of interviews of eyewitnesses in which they would ask them precisely that question. This is astonishing, given that this was a crime scene in which they were in charge, and that's one of the first things you would do is comprehensive interviews with witnesses. I will say a little bit later about what NIST and FEMA and 9/11 Commission report do with such witness accounts. But essentially, we don't know if the FBI has their own private account. So civil society, and I'm a member of civil society obviously, has had to take on the task of this kind of forensic study ourselves. And there's more than one collection, but my own personal collection, which I built up through a lot of hard work, has 156 eyewitnesses to explosions. And I want to say a word about how I constructed this. It's not comprehensive. It doesn't collect all the eyewitnesses, but I'm comfortable with it because I know the criteria that were used to construct it. And I'm going to use it as the basis of the talk. Now, this is one way of arranging the eyewitnesses by keyword. You see, I didn't want to compile a list which said, in effect, this is what Graeme McQueen thinks, right? This is the list of people he thinks saw explosions. I wanted it to be more objective than that. I wanted to remove myself somewhat from the scene. So I chose, after having read the 12,000 pages of the oral testimonies of the firefighters, I chose keywords, read the sources again, made the lists, and here you have the result. So you can see at the bottom, by far the largest number of these eyewitnesses used the word explosion, or a verbal form like to explode. Then we have blast, bomb, blow up, implosion, and a few others. This allows me to keep a little bit of arm's length in my interpretation here. In other words, this is a group of people who themselves said they perceived explosions. That's the point. Now, there are various ways of dividing up this list of 156 eyewitnesses, and I want to show you another way because it allows me to make some other comments. Here I list them by profession. You see by far the largest number are FDNY, that is Fire Department of New York. Next is PAPD, the Port Authority Police Department, then reporters, and then a variety of other civilians. I find this a useful graphic because I think the strengths, evidentially, of the two columns on the left are somewhat different in nature from the strength of the two columns on the right. The two columns on the left here indicate, first of all, government employees, US government employees. Secondly, they're all people who have far more experience with explosions than most of us. And thirdly, and very importantly, the documented evidence that I'm talking about is part of reports and records made in their normal course of their work, and may, for that reason, be legally useful, even though these were made out of court. And I want to give you an example of what these documents look like. First of all, the FDNY documents. Shortly after 9/11, FDNY Commissioner Thomas von Essen decided it would be very important to have a complete record of what the FDNY members saw and experienced on 9/11. So we established the World Trade Center Task Force. There were about 500 interviews, altogether about 12,000 pages, in which members of the FDNY were interviewed by other officers in the organization. And these were taped, the tapes were transcribed, and initially the public did not have access to them. The New York Times thought that we should have access to them and took the city of New York to court. And this is a second example of the usefulness of legal processes in getting crucial evidence. Because the New York Times won, and this was released, and it has proven to be a treasure trove of evidence. Now, this is what the FDNY records look like close up. Here's an example. File number at the top, World Trade Center Task Force interview, firefighter Richard Banachiski, interview date December 6, 2001, transcribed by so-and-so. If we turn the page, we get even more information. Battalion Chief Kenahan gives the date, gives the time, 3:30 p.m., identifies himself, identifies the person he's interviewing, and then asks a very fine open-ended question. Please tell us the events of September 11th as you recall them. And that's pretty typical. For the most part, people are given the freedom to tell the story of what they experienced. Some of them tell it in 2 pages. Some of them tell it in 20 or 30 pages, a great deal of variety. The interviews began shortly after 9/11 and continued into early 2002. Now, in this case, what does Mr. Banachiski say? I've chosen one selection, so you'll see what it looks like. We were there, I don't know, maybe 10, 15 minutes, and then I just remember there was just an explosion. It seemed like on television they blow up these buildings. It seemed like it was going all the way around, like a belt, all these explosions. So that gives you a little idea of what these records look like. Very substantial, extremely rich. Now I want to show you briefly what the Port Authority Police Department records look like. In this case, we're not dealing with interviews. We're dealing with police who simply wrote their reports as part of their normal everyday record keeping and submitted them to their superior officers. Typed in some cases, handwritten in other cases, and I'll choose a handwritten instance. Port Authority of New York and New Jersey handwritten memorandum to Inspector Norris from Police Officer Sue Keene, March 14th, 02. These are a little bit later, but still pretty close to the event. On the above date, I responded from my detail at Manhattan courts, etc., etc., etc. She got there very early. And notice her last line. Writing this down has not been easy. This is my 3rd attempt. This is a traumatized person. It comes through in several of her statements. But let's look at one of the pages of her statements. Massive amounts of debris, concrete dust, and bodies or parts were more frequent at this point. Then there was an eerie silence, and it was like you knew something was going to happen. There just seemed to be one explosion after another. I was separated from the guys from the bridge by another explosion, massive again, sucking the air out of your lungs. And then just a wind, more intense this time, with larger pieces of debris flying, and so on. Very rich stuff. And I should say, Officer Keene was a police officer for something like 14 years. And before that, she was in the U.S. Army. And she says she was trained on how to respond to explosions. It's a credible witness. Now, you've seen a brief indication of what the FDNY and PAPD folks look like, the quality of that documentation. The reporters and other, that is the 2 other columns, are quite different in their strengths, and yet they do have strengths. Many of these are video records, and many of those video records were captured right in the thick of things, on the day. Some people were wounded physically, psychologically, and they made spontaneous statements Whether or not these would be accepted in court as excited utterances or present sense impressions or whatever, I don't know. This will be up to you folks. But in any case, they are saying things spontaneously without reflection, without having a hypothesis that they're pushing, without an ideological agenda or some conspiratorial mindset. And I will choose just one example to give you the flavor, and this is a reporter, N.J. Burkett, working for ABC News and standing right in front of the towers.
All right, take one and two, one. This is as close as we can get to the base of the World Trade Center. You can see the two towers. Debris continues to fall and to rain on the people below. There are people hanging from the windows 90 stories up, and a number of bodies have actually hit the pavement. Take two. Take two and two, one. This is as close as we can get to the base of the World Trade Center. You can see the firemen assembled here, the police officers, FBI agents. The two towers, a huge explosion now raining debris on all of us.
In case you missed what he said, a huge explosion now, raining debris on all of us. We better get out of the way. And that's where it breaks off, because he and his cameraman run for their lives. Later on, he also has to flee for his life when the next tower comes down. And he refers to that as a blast. Okay, well, this will have to do in my brief presentation for corroborating evidence. And I now want to turn to apparently disconfirming evidence, or to put it differently, explanations people have come up with for why we shouldn't take these too seriously. The first objection is, how do we know that these people really perceived explosions? They heard loud sounds, big deal. Could have been falling bodies, crashing elevators, snapping columns, and so on. Frankly, I find that many of the people who make this objection are naive and have not done their homework. They seem to assume that everything people like me are talking about is just vague, big sounds. A person heard a bang, a person heard a boom. I'm sorry, but if that's all you've got, you don't even make it to the list of 156. You haven't identified it as an explosion. Moreover, we're not just talking about auditory perception here. People saw things. They felt things, and these can't be explained in these simple ways. For example, Police Officer Kruger from the Port Authority Police Department, while searching the floor, there was a tremendous explosion, knocking me off my feet onto the floor. Even more dramatic, Port Authority Police Officer Leclerc, suddenly there was a monstrous explosion with extremely high wind and debris, and the lights went out immediately. I was physically picked up and hurled across the concourse, slamming into a wall. I wouldn't want to be the one to tell Officer Leclerc that he didn't really experience an explosion. We can be a little more specific when we try to analyze the data that we've got in arguing in favor of an explosion. I've used James Thurston. James Thurston is a former FBI explosions expert, and he wrote a book, Practical Bomb Scene Investigation, in which he outlines 6 characteristics of explosions. And I've matched them up with statements from Sue Keene, the officer we met before who did the handwritten testimony. And this is what it looks like. First, the distinctive sounds of explosions. Sue Keene says, a couple of minutes later, it sounded like bombs going off. That's when the explosions happened. Second characteristic, positive blast pressure phase, where it moves out, the pressure wave moves out from the point of origin of the explosion, pushing air in front of it. The windows blew in. We all got thrown. Each one of these explosions picked me up and threw me. Now, of course, when the air rushes away from the point of origin of the explosion, a vacuum is created at the point of origination, and that is a characteristic. What does she say? There was this incredible rush of air, and it literally sucked the breath out of my lungs. Nature abhors a vacuum. Next phase is going to be negative blast pressure phase, when things get dragged back and the air is restored toward the point of the explosion. Negative blast pressure phase. Everything went out of me with this massive wind. Stuff was just flying past. Then it stopped and got really quiet. And then everything came back at us. I could breathe at this point, but now I was sucking all that stuff in too. It was almost like a backdraft. It sounded like a tornado. 5, incendiary or thermal effect. He threw me under the hose, which in a way felt great because I didn't realize until then that my skin was actually burning. I had burn marks, not like you'd have from a fire, but my face was all red, my chest was red. And finally, 6, fragmentation and shrapnel. There was stuff coming out of my body like you wouldn't believe. It was like shrapnel. It's still coming out. Now, what I take from all this is that, of course, they were experiencing explosions. This is an objection that does not hold up and is based on sloppy scholarship. The next objection is, well, okay, there were explosions, big deal. We all know that there are various kinds of natural explosions that frequently accompany fires, especially big fires in high-rises. It could have been that. Why do you go from explosion to explosive? There's a big gap there. Well, this is a more sophisticated objection, and it has a certain initial plausibility. But again, I think it doesn't hold up to careful study. I mean, we know what these natural explosions are that accompany fires. They're outlined in the NFPA National Fire, NFPA Guide. And we know what they can and can't do and what their characteristics are. And I suggest to you that the eyewitness evidence rules them out. There are 3 categories, 3 features of the eyewitness testimony that I especially want to draw your attention to. And I call them identification, pattern, and power. Identification simply means, of course, firefighters are trained about these ordinary explosions they may encounter. They know what they are, they know how to recognize them, they know what to do. So do they identify the explosions they encountered in the towers according to these usual categories? Almost without exception, they do not. And here's a way of explaining what I'm saying. 31 separate members of the Fire Department of New York used the term bomb when describing what they experienced. The next point is I call pattern. You already saw in the first couple of videos that I showed that they were talking about patterns of explosions with regular intervals and so on. None of the natural explosions we would expect to accompany a fire exhibit that. And I'd like to give you 2 more examples of testimony from the fire department members that bear on this issue of patterns. Let's start with one that is talking about auditory patterns, sounds. Firefighter Daniel Rivera, speaking of the South Tower. So he's being interviewed here. Rivera says, then that's when I kept on walking close to the South Tower, and that's when the building collapsed. Interviewer asks him, how did you know that it was coming down? Rivera, that noise. It was a noise. Interviewer, what did you hear? What did you see? Rivera, it was a frigging noise. At first I thought it was, do you ever see professional demolition? When they set charges on certain floors, and then you hear pop, 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 pop? That's exactly what I thought it was that. When I heard that friggin' noise, that's when I saw the building coming down. One other testimony worth giving here. Emergency Medical Service Captain Karen DeShore, quote, somewhere around the middle of the World Trade Center, she's talking about the North Tower, there was this orange and red flash coming out. Initially, it was just one flash. Then this flash just kept popping all the way around the building. And that building had started to explode. Popping sound. And with each popping sound, it was initially an orange and then red flash came out of the building. And then it would just go all around the building on both sides as far as I could see. These popping sounds and the explosions were getting bigger, going both up and down, and then all around the building. And finally, I think that explanation does not work because of the feature that I'm calling power. None of the explosions that typically accompany fires could destroy these massive, robust buildings. And yet one eyewitness after another says that's exactly what they saw. For example, firefighter Gary Gates, speaking of the South Tower, I looked up and the building exploded. The whole top came off like a volcano. Well, that rules out the normal kinds of explosions. We're getting toward the end of my talk, but I do have one more question to answer. How did the authorities who produced all these official reports deal with this material? Answer is brief, they didn't. FEMA did not mention it. NIST, I read 4,000 pages of NIST reports and there was not one single mention of this, even though they had access to all the same materials I did. You would not even have known that there were eyewitnesses who thought they heard explosions or saw them. The 9/11 Commission report in its 935 pages has one sentence fragment. It says there were some firefighters in the North Tower. Quote, here it is. Those firefighters not standing near windows facing south had no way of knowing that the South Tower had collapsed. Many surmised that a bomb had exploded. And that's it, folks. That's all there is. This is so extraordinarily deceptive. Most eyewitnesses were not in the North Tower. Many eyewitnesses were looking directly at the towers. They did not have impeded vision. And I've given you examples of this already, but I'll give one more, and he will be my last quotation. Firefighter Kenneth Rogers. We were standing there with about 5 companies and we were just waiting for our assignment, and then there was an explosion in the South Tower. A lot of guys left at that point. I kept watching. That's the key line. I kept watching. He was looking directly at it. And what did he see? Floor after floor after floor, one floor under another after another. And when it hit about the 5th floor, I figured it was a bomb because it looked like a synchronized, deliberate kind of thing. To sum up for you, ladies and gentlemen, I think that this last witness was not only a good eyewitness, I think he was a very smart man who made the right conclusion. All my studies of the eyewitness testimony and of the non-eyewitness testimony have led me to conclude that he was right, that explosives brought down these buildings, and that we are dealing with a synchronized, deliberate kind of thing. Thank you for your patience.
Graeme, don't leave. We have a question for you. Okay. So, Judge, you have a question? Your question, sir?
Green, because I met him in Toronto. Professor Graham Greene is important, credible witness. Nevertheless, it seems to me he is only indirect witness. It seems to me, as he did not show directly the collapse of tower. He has made a nice investigation. and he interviewed different individuals about the dynamic of the. So we know that our code and due process of law does not allow to use the indirect witness. At least that the direct witness are died or irreparable. So I have to ask the professor if he has written the name of the individuals that he questioned, if he gave to the FBI or the police or the prosecutor his dossier in order to ask to investigate this person, because it seems to me that several of these witnesses are irreparable. It is impossible to find them. So, as I believe that he is a very important witness, he must help us in finding the direct witnesses and giving us also the document that allow us to speak with the direct witness. Thank you.
Thank you. There are several points in there. I don't know if I can answer them all. First of all, I am going to be handing to the panel a list of all the 156 people with their names and their exact testimony, as near as I can figure out where they were, when they gave the testimony, and so on. Secondly, I realize this is considered indirect, that in other words, these are out-of-court statements, they were not made under oath, and therefore this is an example of where I say these are historically of extreme importance. Whether they are admissible legally, right, will be, I think, up to you guys to figure out. I tried to give a couple of little hints in that direction because I'm aware that there are exceptions to the hearsay rule, including certain kinds of records and certain kinds of spontaneous statements. But whether or not that will work, I don't know. The other way to go is to say, look, this isn't ancient Rome we're talking about here. This is New York City 15 years ago. A lot of them are still alive. For heaven's sakes, why don't we bring them into a process, either affidavits or in court or whatever? I'm not the guy to do that. And if it is done, it has to be done very well. You may only get one chance at it. You don't want to blow it. But these are different routes that may be taken.
We must try to find them. So if they are irreparable, if we don't find, we can use your witness. Yes.
Yes, you can use the list.
Tell that because the code, criminal code,
yeah,
foreseen that if the direct witness, it is impossible because of death, of their death, of the disappearation, that we can use your witness that is very, very important and credible.
Okay.
Thank you very much.
Thank you.
That's fine. So we're running short on time, but I unfortunately will have to exercise the prerogative of the chair here and make a statement myself. I apologize to those who are wanting us to proceed, but first of all, Judge, be assured you're essentially preaching to the choir to this panel of lawyers in terms of the need to get the original witnesses and eyewitness testimony under oath from the people who were there. So that, rest assured, your advice is received. On the other hand, I do agree with Dr. McQueen that there are exceptions under the federal rules of evidence for admissibility of certain testimonies or statements out of court. Not necessarily the preferred evidence, but it is allowed in some circumstances, such as excited utterances, present sense impression, and the recording of these statements made by the, I believe it was the state government of New York, to archive these firefighters' testimonies may qualify as a public record exception. So it's not like this information wouldn't be receivable in a court, but your point is still well taken. To be persuasive, you would want the best evidence you can lay your hands on. Normally, that would be the eyewitnesses. I also will just make a quick note since it's relevant here. You'll hear it again in a moment. Grand juries in the federal system are not only allowed to hear evidence that is not admissible, they're allowed to issue a presentment leading to an indictment based entirely on hearsay. That's the federal system. So the information is very valuable. We thank you, Dr. McQueen.
Thank you.
We're going to look next at legal standards that relate to specific crimes in grand juries. Lawyers here are going to attempt to explain what is required in order to initiate a grand jury and prosecute certain crimes, such as arson, murder, conspiracy, and terrorism that may have been committed on September 11th. The panel will include Dave Meiswinkle, Mustapha Ndanusa, and Mick Harrison, with guest panelists Daniel Sheehan and Judge Imposimato. Okay.
So I will begin, Nick Harrison, with the federal standards. We will proceed then to my colleague, Mustapha Ndanusa, on the New York standards, and proceed then to my colleague, Dave Meiswinkle, on the New Jersey standards. We have a lot of material to go through here, and so I apologize for the speed at which we will be moving through it. So my organization, the Lawyers Committee for 9/11 Inquiry, is contemplating, in terms of future actions, several things. One is that we're considering a request for a federal grand jury. We're also considering future civil litigation, as Daniel Sheehan has explained at some length. We're also considering filing a felony complaint in New York, which you'll hear a little more about. And as Judge Imposimato has noted, we are also considering an international forum for a possible prosecution. Now, under the, so let me see if I can get on the right slide here. Okay, so the first federal law I want to bring your attention to, and this is as much for the panel as for the audience. This is Title 18, U.S. Code, Section 2332F, bombings of places of public use, government facilities. This is one of the terrorism statutes. It defines it imposes criminal liability on anyone who unlawfully delivers, places, discharges, detonates an explosive or other lethal device into or against a place of public use. Now, as I go through these definitions of crimes, of course, I want you all to keep in mind the evidence you've heard today, and perhaps some of the evidence you've heard yesterday. There has to be an intent to cause death or serious bodily injury, or if there is no such intent, there at least has to be the intent to cause extensive destruction of the place where such destruction results in major economic loss. And if those standards are met, then that crime could be prosecuted. There has to be certain conditions met for federal jurisdiction regarding this particular crime. I won't go into all the technical legal details. If the offense takes place in the United States and it is committed in an attempt to compel the United States to do or abstain from doing any act, then there's jurisdiction. Now, you might wonder why I mentioned that, but there is one of the areas we're inquiring into is whether the buildings were destroyed, as explained by the scientific witnesses, in order to motivate the United States government to engage in one or more wars, which we did see progress after this crime was committed. So in my view, jurisdiction would be present on that basis. There's an alternative basis for jurisdiction if you did not accept that basis, and that is that one or more victims were from another state, in this case, state in quotation marks, meaning another nation, another country. That condition is unfortunately satisfied here as well. There are some exemptions to jurisdiction that don't apply here. Because we are short on time, I'm going to not go into those details, but the panel members can grill me on that later. And these slides will be posted on our webpage, www.lawyerscommittee-for9-11inquiry.org. So if you need to see the details later, you can find it there. The next federal law we'll talk about is same title, 18 U.S. Code 2332B, Acts of Terrorism Transcending National Boundaries. This law applies only when one of the perpetrators has done something across the boundary of a nation. It involves killing or otherwise injuring seriously a person, or doing something that creates a substantial risk of that type of injury, or damaging any structure within the United States in violation of the laws of any state or the United States. If those conditions are satisfied, there is a crime. And as with many laws, and essentially every law in the federal system, anyone who attempts to commit the crime has criminal liability. And so keep that in mind as we go forward. There are jurisdictional requirements. As I mentioned, hang on, let me get my okay. So we have acts of terrorism. We got that. So we want to go. Sorry, being slow here. Another crime which could be involved in these particular acts we've been talking about has to do with destruction of government property. You might wonder why I mentioned that, because these were the World Trade Center buildings. In a couple of those buildings, as I understand it, my colleagues will correct me if I'm mistaken, federal agencies had offices that they were renting, and of course they had their own property in the buildings. So there was likely jurisdiction for this crime as well, willfully injuring or committing any depredation against any property of the United States or any department. I mentioned in relation to the other law that if you're attempting to commit the crime, there's liability. There's also liability for co-conspirators, accessories, and those who aid and abet. Similarly, if someone provides material support to another person who commits one of the crimes I've mentioned, in this case the terrorist crimes, they also have liability. Material support can include giving money. It can include giving training, expert advice, explosives, transportation, or other support. There's another law that some of you may not realize why it would apply, Title 18, Section 1114, Protection of Officers and Employees of the United States. Whoever kills or attempts to kill any officer or employee of the United States is, of course, committing a crime while such officer is engaged in or account of their duties. You may not remember, unfortunately, again, that there was one FBI officer who was killed in the buildings when they were destroyed, and there was one Secret Service officer who was killed. So in my view, this law would apply. There is, most of us are familiar with the concept of treason. It is a federal statute, Title 18, Section 2381. Anyone owing allegiance to the United States who levies war against the United States or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason. Most of us know this crime has a death penalty as an option. There are some ins and outs of the treason law we don't have time to go into. but it is one that I think we'll be looking at. This general conspiracy statute, which is still Title 18, Section 371, conspiracy to commit offenses or to defraud the United States. Essentially, it is a crime to conspire to commit one of these other offenses if any one of the persons in the conspiracy does any one act to affect the object of the conspiracy. The next statute we'll look at, which we'll be examining, is called misprision of a felony. And this one is worth some careful thought. Whoever having knowledge of the actual commission of a felony, we're not talking about doing the crime, we're talking about having knowledge of the crime. Whoever has knowledge of the actual commission of a felony, who conceals and does not, as soon as possible, make known the same to some judge or other person in authority, is guilty of this crime. So anyone who came to know of these crimes would have liability under this statute if they did not relay their information as quickly as possible to the proper authorities. I mentioned this earlier. This is the statute that says it, Title 18, Section 2. Anyone who aids, abets, counsels, commands, induces, or procures the commission of a crime is punishable as if they'd committed the crime themselves. That's Section A. Section B, if someone causes an act to be done, which if directly performed by that person would be a crime, that person who caused the crime to be committed is also guilty of the crime. We also have obstruction of proceedings before departments, agencies, and committees. It is a crime if someone corruptly influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States. For example, in my view, an FBI investigation, a commission, maybe the 9/11 Commission proceedings, and also if anyone corruptly obstructs, influences, or impedes the due and proper exercise of the power of inquiry under which any inquiry or investigation is being had by either House or any committee of either House or any joint committee of the Congress. What comes to mind there might be the joint inquiry that was done in 2002, 2003. So anyone who does that is committing a federal crime. Now, there are some statute of limitations. I won't spend a lot of time on this, but most of you know if you wait too long, you being the prosecutor, you may lose your ability to prosecute a crime. That is only true for some crimes. The first statute I will bring to your attention on this is capital offenses. It probably won't surprise you that if an offense has a death penalty associated with it, that there is no statute of limitations. The crime can be prosecuted at any time. Now, the general statute of limitations, which comes under Section 3282, is 5 years. But if you'll notice the beginning clause there, except as otherwise expressly provided by law. So it's 5 years unless there's another law that provides otherwise. Now, I just gave you one law that provides otherwise, which is for capital offenses. Now, let's look at another statute. This is Section 3286 of Title 18, extension of statute of limitations for certain terrorism offenses. Now, Section A extends that 5-year period to 8 years, but Section B is the one of most interest to us given the time frame in which we're now working. And Section B says, as you can see, hopefully, no limitation, notwithstanding any other law, an indictment may be found or an information instituted at any time without limitation for any offense listed in Section 2332B, G5B, and I'll just tell you to save us some time, that list referred to there includes the 2 terrorism offenses I presented to you earlier. So in this case, if, as it says here, the offense listed, and I've presented 2 of them to you under the terrorism statutes, if they resulted in or created a foreseeable risk of death, or serious bodily injury to another person, then there is no time limitation for their prosecution. There's another exception that I'll mention, and I'll go on to talk about the grand jury, and that is if someone is fleeing from justice, and there are some ins and outs of how the law defines fleeing from justice, but if someone attempted to conceal themselves after these crimes, the statute of limitations would not run on the crimes that they committed. I want to move now to a brief discussion of standards applicable to grand juries, because that is one of our anticipated future actions, which is a petition for a federal grand jury, a New Jersey grand jury, and a New York felony complaint. Now, the law I'm about to give you quickly is only for federal grand juries. My colleagues will be talking about New York and New Jersey. So the grand jury requirement, as most of you know by now, comes from the Fifth Amendment of the U.S. Constitution, so it's a requirement based in the Constitution itself. The only way someone in this country can be prosecuted federally for a felony is if a grand jury makes a presentment or an indictment, which basically says the grand jury has found in its own judgment that a crime has been committed and that this suspect is responsible for the crime. So it's a constitutional requirement and entitlement for anyone who is to be prosecuted for a felony. Now, some of the rules in the federal system, and you may not realize this, the grand jury is to act independent of both the prosecutor and the judge, which means the prosecutor under the law cannot tell the grand jury what to do or not to do. Neither can the judge. Now, you'll probably hear some discussion later that the system doesn't always work as defined, but this is how the law is stated. The grand jury is independent. It's not, as the next quote I have here says, not captive to any of the three branches of government. It is a constitutional fixture in its own right. The purpose of a grand jury, its mission, and its duty is to determine whether there is probable cause to believe that a crime has been committed, one, and that a suspect in particular has committed the crime. Now, what that doesn't mean, however, is that for a matter to be presented to a grand jury, the persons bringing the evidence forward, perhaps such as our lawyers committee, has to have named a suspect already. The grand jury can pursue an investigation to identify the suspect or not. So, but before a grand jury can make a presentment for an indictment, they have to, in their own view, determine probable cause that a crime was committed and that a particular suspect had committed the crime after they finish their inquiry. Now, the grand jury has broad investigatorial powers into what might be federal crimes. The grand jury does not have to rely on the prosecutor to tell it what evidence to inquire into. Again, there may be some slippage in terms of actual practice with grand juries and whether the grand jury is actually well educated on its powers and is allowed to exercise them. But under the law, the grand jury can pursue its own investigation. There is some distinction to be made, which we probably don't have time for, unfortunately, between presentment and indictment. It's an important question. We may get into it in the discussion. I'm going to skip over that one. So let's look at what is it that the grand jury is allowed to look at. So the Constitution does not prescribe or proscribe what kind of evidence the grand jury can look at. It can look at whatever it wants to look at. I mentioned earlier it's allowed to look at hearsay evidence. That is the law in the federal system. The grand jury does not have to go by the federal rules of evidence. That comes later if there's to be a trial. So the grand jury's scope of inquiry is broad and it's flexible, and it's up to the grand jury to decide what to look at. Any evidence that reasonable people might use to reach a logical conclusion is allowed to be examined by the grand jury under federal law. So this is redundant, but it's important that you understand this. The Fifth Amendment does not say that only admissible evidence or legal evidence may be received by the grand jury. It does not say that. So let's go on to a new point. Now, if a grand jury makes a presentment leading to an indictment, the defendant can be tried, even though, as this case I'm citing here, I'm not giving you the citations, it'll be on our website. These are all federal cases. Even if the evidence and allegations are what we might call minimal under the law, if the grand jury decides they're persuaded, that's enough for the trial to go forward and the indictment to go forward. There's no requirement that the evidence be of any particular kind. Hearsay is allowed, as I mentioned. And there's even a case that says, even an indictment based on hearsay, incompetent and inadequate evidence would not be void. The key here is, this is the grand jury's job. It's not a judge's, it's not the prosecutor's. So the grand jury makes up their mind whether the evidence is sufficient for a presentment to lead to an indictment. So keep these standards in mind as you think about the evidence you just heard. So I think we're ready to move to my colleagues. So Mustapha, if you wouldn't mind giving us your summary of the New York grand jury law.
Everybody hear me? All right. How many people here are lawyers? By show of hands. Not that many, so this might be terribly boring to many of you, but I'll try my best to make it as interesting as possible. As Mick mentioned, there are many different types of crimes that we can sort of outline here. I'm going to try to focus more on homicides. If and when the time comes to file a complaint, I guarantee you the complaint will be as long as from here to that door or even longer. Because there are just so many crimes that you can think of what happened on that particular day. One of my favorite crimes that you can accuse somebody of is always a ubiquitous, conspiracy. You can always get somebody laced into a crime by charging them with some type of conspiracy of sorts. So in New York, in terms of the list of the different types of homicides, some of them I'll just mention here, you have criminal negligent homicide, which is like an E felony, which means that it carries a sentence that does not exceed 4 years. So criminal negligent homicide is a criminal negligence, which means that a person fails to perceive a substantial and unjustifiable risk that causes death to another person. You have aggravated criminal negligent homicide, which is just like the first one, except that it's when you cause the death of an officer when the defendant knew or should have known that the victim was an officer. And we know that a lot of people who are officers, not just a police officer, it could be a peace officer, a fire person, where many people lost their lives that were in public office or people that can be considered officers on that day. You have manslaughter in the second degree, which is recklessness, or when a person recklessly is defined as aware of and consciously disregards a substantial and unjustifiable risk, and to disregard it as a gross deviation from standard conduct. That the person acts recklessly and causes the death of a person, or commits abortion, or intentionally causes or aids another person to commit suicide. That would be recklessness, or manslaughter in the second degree. You have manslaughter in the first degree, which is an intent to cause physical injury that causes death. As you see from the first one, it's not necessarily an intent, but rather is a deviation from standards, like a gross deviation from standard, as opposed to manslaughter one, where it's a person is acting intentionally, but the intention is not to actually kill someone, but the intention is to cause injury to someone, but then it ends up causing the death of a person. And then, of course, you have the ever popular murder, which I don't really need to explain to you what that is. It's just the intention to actually kill someone, which results in the death of a person. New York also has its own independent terrorism law, separate and apart from the federal terrorism statutes. It has its own terrorism statute and also has providing material support for terrorism. And material support can be defined very broadly, as many of you who have been following some of the material support cases know. Just offering water to a person that's supposed to be a terrorist might be considered material support. I represented a guy in the early stages who was, it was an Al-Manar TV, which is like the Hezbollah TV. And what happened in this case was that he had a particular machinery that he had fixed so that Al-Manar would be able to broadcast their television. And that was providing material support to a terrorist group. So as Mick also mentioned, there are statutes of limitations in every crime, with the exception, of course, of crimes that can be punished by a death penalty. And in New York, we don't have the death penalty. We had it for a very short time recently, and then it was abolished, but we do have life imprisonment. And life imprisonment is applicable to those crimes that are A felonies or A1 felonies. And the difference between them basically is whether or not the person who is the victim is a regular citizen like you and I, or a police officer, a judge, a peace officer, people in sort of the public sphere who are acting as some kind of public officer. But they all carry life imprisonments. So the statute of limitation for felonies, and a felony is defined as any crime where the punishment can exceed a year in imprisonment, not whether or not you actually get the year of imprisonment, but whether or not the penalty is a year imprisonment. The statute of limitation is 5 years. But for A felonies, there is no statute of limitation. And also, when you have acts against public servants, in this particular case, this would be important. If the act, the homicide, results in the death of a public servant, like a police officer, then the statute of limitation starts to run not from the date of the commission of the act, but from the date that the person who committed the act or who you're accusing of committing the act actually leaves service. So it's 5 years from that date. So in terms of juries, as you know, there are two types of juries. And to me, they feel like they are sort of misnamed. The petty jury, which is like the small jury you would think would be the secret jury, is actually the public jury. The petty jury is the jury that you're all accustomed to, that you see on TV. So think, perish of thought, but think O.J. Simpson when you think petty jury. That's the kind of jury that we're accustomed to. The grand jury, which you would think because of grand, it's kind of open, is not open to anyone. It's actually secretive. Definitely in New York, it's secret. And in fact, you are prohibited from speaking if you serve as a juror on anything substantive that happened with respect to testimony, any other type of evidence, unless a court or a judge believes that for the benefit of the public, it is worthwhile then unsealing, I guess, the grand jury testimony, so that now the grand jurors would be allowed to speak about what it is that they heard in terms of testimony and evidence. And then you also have sort of like this other third category of grand jury, which is like an extraordinary grand jury, which may actually be applicable here. So in the petty jury, it's when they will come back and give you a verdict. Is a person guilty or not guilty? A grand jury is whether or not the person is going to be indicted or not indicted, meaning that there's sufficient evidence to believe that a person might have committed a crime. Therefore, the prosecutor now has the right to take the indictment and move forward to trial. The extraordinary grand jury is a little different. They will be given a specific task. Tell us whether or not the crime has actually been committed, sort of. Whether, particularly in this type of scenario, you heard a lot of different experts speak earlier about the types of evidence that's out there. So an extraordinary grand jury would be appropriate, maybe even for a situation like that, where they would look at the evidence and determine whether or not a crime has been committed and possibly who committed that crime. Whereas with the grand jury, you already have a name of a person that you believe has committed a crime, and then you want to know whether or not there's sufficient evidence to charge that particular person with a felony. As Mick also mentioned, that the power of, or the right to a grand jury comes from the U.S. Constitution. In New York, it comes from Article 1, Section 6 of the Bill of Rights, that no person shall be charged for capital crime or infamous crime except by grand jury or waiver of information. An infamous crime is not sort of what you think. Usually it's defined by the type of punishment that a person is going to get. Meaning, like, if it's going to be a felony, then that's usually the way the courts have defined an infamous crime. And the force of the grand jury, although they are an independent body, separate and apart from the court and the district attorney, the district attorney and the court serve as sort of advisors to the grand jury. Once they have been convened, the grand jury now can independently subpoena people to come and give testimony, and that subpoena is going to be served by the DA's office. So, I don't know, maybe this is an appropriate analogy, but the grand jury is sort of like a knight, and the district attorney is like the horse that they ride to go to different places and figure out whether or not a crime has been committed. And the court is there sort of like an arm of the government that empowers them to do these different type of things. The grand jury are drawn from a pool. It consists of at least 16 people and no more than 23. And in order for them to make a decision whether to indict or not to indict, you need at least 12 people to make that decision. And the type of evidence that the grand jury can hear, they do hear a certain sort of level of hearsay evidence, but generally the agreed upon legal standard is that the evidence that they hear has to be legally sufficient, meaning that the evidence that is not non-hearsay evidence is competent evidence which, if accepted as true, will establish every element of the crime. So I'll just give you in conclusion, for example, because my time is running short, if you take a crime like criminal negligent homicide, which is the person acted negligently causing the death of another person. So you have to have enough evidence that would show that the person actually acted negligently and that the person's life was taken because of that act. There are other sort of elements that come along with every single crime, but the evidence that has to be produced at a grand jury for every single act alleged has to be able to prove as competent evidence every element of the crime that they are being charged of.
Thank you. Thank you. So now we'll invite David Meiswinkle to explain the New Jersey law regarding grand juries and certain crimes. David, could you do that?
Good afternoon. How you doing? It's quite an honor to be able to make this presentation on behalf of New Jersey. I'm going to put up a friend. I'm with the American flag, and it's such an honor. I'm proud to be here. There's a guest we have to invite. I'm going to put him at the table with me, or with my colleagues, if I can. Right, that's the Bill of Rights. It was first written up here in New York City. The first state to ratify the Bill of Rights was New Jersey in 1789. Now, my colleagues have talked about the federal courts as far as doing some kind of legal action as far as a grand jury and or the state of New York. There's another state involved greatly here, and most of us don't know about the connections. So I'm going to tell you a little about the connections, and we'll talk about the New Jersey grand jury. Question, does New Jersey have legal connection or a nexus to the crimes of 9/11? Does New Jersey have legal standing to investigate these crimes and criminally charge suspects? And I would say categorically, yes. What are the connections? Over 681 victims in New Jersey. In 17 of the 21 counties. a plane was hijacked out of Newark, New Jersey, Flight 93. Anthrax attacks in Trenton, Princeton, and Hamilton, New Jersey. Terrorist cells operating in Patterson, New Jersey, Wayne, New Jersey, of which Mohammed Atta, the alleged leader of the hijackers, Hani Hanjour, the alleged pilot of Flight 77, Marwal Hashashi, Nawal Hazmi, and Khalid Almadar, the last two, were the two alleged terrorists mentioned in the San Diego and connected with the 28 pages. They were right in New Jersey. Altogether, 7 conspirators allegedly in New Jersey. Also, they were training at Teterboro and Fairfield airfields in New Jersey. And all this steel, the tons, the hundreds of tons of steel that came out of New York City, most of it went to 3 scrap yards in New Jersey, where it was cut into 5-foot pieces and sent over to Asia. So the question is, does New Jersey have a connection? It certainly does. Does it have legal standing? Yes, it does. It has a federal court also in Newark, not far from here, also in Trenton and also in Camden. Now, just to get the little background, because as attorneys, we have to decide, you know, and as Danny Sheehan said before yesterday, you have to know your plaintiffs, good plaintiffs, and who you're going to, you know, who your defendants are, and, you know, how we should go about investigating. Now, does New Jersey have the backbone to do this? I would say categorically yes, karmically yes. New Jersey is known as the crossroads of the American Revolution because more battles were fought in New Jersey than any other area, any other state. George Washington spent half his time in New Jersey, over 4.5 years after he left New York City, barely getting out of here. 2 of the most important battles of the American Revolution were in Trenton and Princeton, New Jersey, which totally changed the reflection of the war. And as I mentioned to you before, New Jersey was the first state to ratify the Bill of Rights. Now, with regards to the standards, a grand jury in New Jersey is 23 people. And as Mustapha mentioned, the grand and the petit. The petit jury is the little jury, the 12 people. And the big grand jury is 23. In order to get an indictment in New Jersey, you need 12. You need a quorum of 12 people to indict. Indict is really just the official charge of a crime. Now, New Jersey law is codified, or it's in New Jersey Constitution, Article 1, Paragraph 8. No person shall be held to answer for a criminal offense unless on the presentment or indictment of a grand jury. The grand jury is a judicial investigative body with broad investigative authority to determine whether a crime has been committed and whether criminal investigation should be instituted against any person, holding that a grand jury remains a constitutional bulwark against hasty and ill-founded prosecutions and continues to lend legitimacy to our system of justice by infusing it with the democratic ethos. Now, the grand jury really is mentioned, why I put in part the Bill of Rights up here, besides all the amazing things that it gives us, is all our freedoms, is also the Fifth Amendment has to do with the grand jury. That's where it's mentioned. And as far as being mentioned in the Constitution, it's mentioned in the Bill of Rights and the Fifth Amendment. And that's really the people's court. I mean, you don't think of it as that, but that's what it's about. In fact, even in a petty trial, you have the jury decides the guilt or innocence of the person. And in a grand jury, theoretically, they decide whether they're going to indict somebody or whether they're going to make a presentment against someone. Now, I've done hundreds of criminal cases. I've read hundreds of grand jury indictments, the transcripts, from little things like when prostitution or burglary up to homicide. And it always seems like the prosecutor is basically directing the activity. You'll have some independent jurors once in a while, and you say you're reading it. Oh, good, somebody asked a question. But it usually doesn't go that way too often. It's pretty easy to get an indictment. What's amazing is that now, 15 years since 9/11, there has not been one grand jury that I know in the entire United States. Not one grand jury. Never been a federal grand jury, never been a state grand jury, and now we bring in the crime of conspiracy. These conspirators were in many states. The grand jury is an independent legal institution under our Constitution as a representative of the community. It is an arm of the court, not part of the prosecutor's office. The grand jury does not assist the prosecutor. The prosecutor assists the grand jury. The grand jury charge continues. However, you are not limited in your investigation to matters brought to your attention by the prosecutor. As a group, and as determined by a majority of the grand jurors present, you may decide that conditions exist that warrant investigation because you believe a crime has been committed. In that connection, you are empowered to require the production of evidence, to compel witnesses to appear before you, and to return indictments if the evidence justifies the action. The prosecuting attorney is available to advise you on legal questions, and if necessary, you may request additional instructions from the court. Now, I had a question as to how do you get the information before the grand jury. So I thought about it, and 12 hours later, I ran into the second in charge in the county where I do most of my criminal work, the prosecutor, the deputy prosecutor. And I asked him, where do you go for this? Because I've talked to attorneys 35 years, and they don't know. And he said, without thinking, I thought he was going to give me something else, the assignment judge. I said, fine. So I called the assignment judge up the next day. Unfortunately, he was on vacation. However, his assistant was there. She says, I'll have someone call you. Someone called me. The assistant assignment judge, a judge, actually called me. I was really honored and very nice. And I told him, listen, I have no citizens. I have citizens groups that have a major concern they want to bring before the grand juries for investigation. What do they do? Here's what he told me you do. He said, write your concern, put it in an envelope, address it to the grand jury, then take that envelope and put it in a bigger envelope and address it to the assignment judge. The assignment judge will get it, and then you give it over to the grand jury for action. Now, in New Jersey, the homicide, of course, is you could always have an action for that. There's no statute of limitation. Unfortunately, the Terrorist Act, the Anti-Terrorist Act in New Jersey was brought in 2002, the year after. But nevertheless, you have an action you can do for a prosecution of terrorism, and it's called hindering apprehension for prosecution of terrorism, and that would be no limit on that either. So in conspiracy to commit murder, I believe in the hindering apprehension or prosecution for terrorism, there would be not a limit, and I also believe that there may be racketeering charges also. I'm running out of time, but it's been a pleasure to be here. And listen, when we look at the Bill of Rights, it's reflected in you being here, all right? This only lives if we believe in it and we fight for it, basically. All right? It represents us. If you think of what it means to be an American, the purest thing distilled down, I believe, is in this Bill of Rights and this flag. This flag can't stand unless that Bill of Rights is upholded. And that's what we're all about. I believe that's what architects and engineers is about. I think that's what the legal profession is about, the people that are here. And that's eventually what the police and the military and the whole population is going to be about. All we got to do is show them we're really the Americans here, and the true American spirit is represented in that document. Thank you.
Thank you, David. Before we go to our next session, which is a substantial one, about whether a grand jury may be warranted in light of the legal standards you just heard and the evidence you've heard earlier, I want to give our special guests, Daniel Sheehan and Judge Imposimato an opportunity. They don't have to take advantage of it since we're short on time, but if they want to make some comments on our explanation of legal standards, we would welcome it.
Focusing just on the criminal grand jury aspects of this, I think that this is very, very clearly covered the causes of action and the theories of the case and the range of liability that would exist under criminal statutes. As I pointed out yesterday, however, I mean, I fully appreciate the reference from the assistant assignment judge in New Jersey, but the reality of it is that the federal and state prosecutors have so effectively interposed themselves between the grand juries and any type of a complaint that a civilian would make. And I've tried this a number of times to bring complaints to prosecutors, bring complaints to federal prosecutors, et cetera. That all the judges, all the prosecutors view themselves as being the ones who have the authority to make the decision as to whether or not a case is going to go forward. And I can pretty much assure you that if in fact you did address a potential criminal complaint to the assignment judge and put that in the envelope, they would bring it to the prosecutor. They would bring it to the district attorney, and they would say, "What do you think of this? Do you think this merits going forward?" So I would just suggest that the substantial portion of our effort should be directed toward the civil litigation, which we'll talk about afterwards, I think. But the bottom line, under the various types of, the rare types of statute that exists that allows us to engage as private prosecutors, as prosecutors on behalf of the people, all of these criminal elements apply. And I would very strongly recommend that any case that is prosecuted civilly be prosecuted just exactly like a criminal case, and that you call upon all of these different elements. You show that in fact the Congress has made a decision to give a private civilian set of lawyers the authority to go forward in the name of the people, and that you prosecute it just like a criminal statute, and that we'll talk about the rare civil provisions, the Federal Racketeering Act, the new Anti-Terrorism Act, and some discussion about the Federal Civil Rights Act, about whether or not these would be available. But I strongly urge the use of the criminal standards, the criminal elements of a crime, to prosecute them.
Thank you, Danny. Would the judge like to make any comments on what was just said? Not required.
This procedure is different from Italian procedure. It is very complicated, as in, which correspond to grand jury. So the procedure is that I want in few words tell you is that the prosecutor must ask to the judge if he want to assess responsibility, and it is impossible for the victims to go directly to the grand jury. Here I have understood that there is this possibility that the injured parties can go to ask to grand jury to make a process before the court. But I have asked to you the two elements. One is the evidence that the crime, and I have the evidence that the crime have been committed, crimes, murders, weapons, terrorism, and other crimes. Another thing that I have not understood is if it needs to have a indicted people. The second element, that the people that must be judged by grand jury. But we have not spoken about the possible indicted, accused of this crime. We have many crimes about the fact, the crimes, but we have no evidence or less evidence about the people to be judged. So I think that our judgment about the possible petition required before the examination, but that we cannot do now. I think that we have not possibility. I have in mind several people that I would indict, accuse them. I have. And for me...
Don't mention them right now, please.
Eh?
We'll talk later.
I have some names, and one is, for example, is the chief of the service secret Pakistan. He founded Mohammed Atta, and because he is a citizen Pakistan, there is no problem of competence. Another one is Omar Saed, because they founded Atta, and this is possible other the officers, the secret of the Saudi government. And anyway, I think that we have to examine before the evidences against the people, because it is impossible to establish to make a petition without knowing the name of the...
Let me interrupt you, Judge, and explain. I understand your point and your question. My view of federal law, and I suspect at least one of my colleagues' views of New Jersey law and possibly New York, I can't speak for New York yet, is that if there's evidence of a crime, and we've heard quite a bit of evidence of a crime, not only can citizens present that information to a prosecuting attorney or a New York judge, or maybe in New Jersey a judge, for the purpose of having it transmitted to a grand jury, the grand jury can be initiated, an inquiry can proceed on that crime prior to suspects being identified, but no presentment or indictment can proceed to be issued until the suspects are identified. So it is not my view, and which may be contrary to yours, and that's fine. Lawyers occasionally disagree with each other. You may or may not have noticed. But it's possible to initiate a grand jury without the suspects being identified. Having said that, the reason that my organization and our members are not preparing presentations today about suspects is not because we don't have some evidence pointing to certain suspects. We have decided strategically to put that information regarding specific potential defendants into the petition to be submitted to the Attorney General or to a court or the prosecuting attorneys. There is a privilege under the law in this country for such submissions, so they would be immune from, for example, a defamation suit. So we have a reason for our procedure that we're following, but I appreciate your point. And we are running over time, and I apologize to everyone for that. So we do now want to move, if Mr. William Pepper would help us and introduce our next session about whether grand jury is warranted.
next discussion that the panel has to deal with is some of the nuts and bolts of when and if a grand jury is actually warranted. This will have to do with an analysis of the evidence with more specificity in terms of presentation to a grand jury, and to determine, in their view, whether or not the evidence is sufficient to justify a special grand jury to yet to be acknowledged crimes that may have been committed on 9/11. So we'll stay with the same panel of Dave Meiswinkle, Mustapha and Ndanusa, Mick Harrison, but I have also Andrew Krieg here. I think I saw Andrew leaving.
Yes, we invite, well, if Andrew's gone, that's fine, but we'll invite him back if he's here. And Bill Veal, if Bill is still here, he's welcome to join us.
Okay.
If not, we'll
Dave
proceed.
Meiswinkle, Mustapha, and Mick Harrison.
Thank you. So we want to attempt, and I address this to my panel members, attempt to save time since we're running a little over. So make your comments as brief as you can without losing the gist of what you want to say. So the question being posed to you at the moment, as lawyers, is whether the legal standards you've heard described, in light of the evidence you've heard presented, would, in your opinion, speaking only for yourself at the moment, warrant either a federal grand jury, or if you wish to offer an opinion on a New York grand jury, or if you wish to offer an opinion on a New Jersey grand jury, and you can make your opinion specific to a particular crime or not. In the interest of time, I leave that to you. I want to proceed in a certain order, and I want to start with Danny Sheehan, and then I want to go to Judge Imposimato, and then I'll come to my colleagues here. And if there's any time left, I will add my thoughts. Mr. Sheehan?
I would actually say that at the present time, without a more focused investigation that was able to, in a potential petition to a grand jury, to designate specific people with specific accusations of specific overt acts that they undertook, et cetera, connecting them to particular criminal statutes, that there's not a more than a 1% chance, in my opinion, that any present judge or state or federal judge or prosecuting authority would allow the petition to be put in front of a grand jury. And if they were to make such a decision, that they would, the prosecuting attorney in that jurisdiction would be authorized by the judge to supervise that grand jury, and they would undertake an aggressive campaign that wouldn't take them more than a couple days to get the jury to return a no bill. So that I would very clearly reemphasize what I've said any number of times, that the avenue that needs to be pursued here is to take one of the statutes, one of the rare statutes that has been passed by legislature, state and federal, to authorize private attorneys to function as a private attorney general, to do the prosecuting in a civil context. I believe that's the way to go on this. That I don't want people to be illusioned into thinking that simply because there's a conceivable way that this might be done. I think that the judges that have been appointed over the past decade and a half at all levels are not disposed toward unorthodox procedures. And so that I would suggest that given the extraordinary nature of the crimes that are being investigated and the nature of the prosecution that is being proposed, that it be undertaken in as orthodox a way as we can, pursuant to those handful of civil statutes, such as the New Terrorism Act specifically. And conceivably, RICO is a much more limited thing than most people think it is. It has to be prosecuted on the basis of damage to your property or business, and people aren't aware of that. So the people can go around killing people all over the place and do it as a criminal enterprise, even as a racketeering enterprise. but the only people who have a legitimate standing to move under RICO is those who've had their business property damaged. So I would think that that's likely not to be available to us with all of its great procedural advantages that it has. So I would, but under the Terrorism Act itself, I would propose that we are clearly going to be entitled, or one would be entitled to argue that there's a conspiracy here and utilize many of the same procedural advantages of RICO under a civil conspiracy, and borrowing again from the Federal Civil Rights Act to use that as a conspiracy theory to bring people in as co-conspirators and attribute to them the overt acts of others. So that's how I would very strongly propose that that this be pursued pursuant to Title 18 United States Code 2333A, the statute that gives us authority. And I hasten to point out that the statute of limitations that would apply to this would require, and I think this is an important thing for the word to go out from this point forward, this case has to be filed by January 2nd of 1919 because there's an 18-year statute of limitations that functions. The lifting of the criminal statute of limitations for a death case, I don't think is going to be applied in the civil case here. There's an 18-year total statute of limitations from the day of the events. We sit here at the 15th anniversary, so we have approximately 3 years left to make the decision to bring this case under that new provision. And that's how I would do it. And I think that the discussion about the standards, et cetera, to be used in a potential criminal prosecution are helpful, but that the venue needs to be different than a grand jury.
Understood. Judge, would you like to add some comments on whether you feel a grand jury is warranted or some other type of action as Mr. Sheehan has offered?
I agree with the lawyer. My friend is very prudent. It is we need to be prudent because I think that we can make a good investigation as a legal of victims of legal of this association. And I ask you, this association of lawyers committee has juridical personality in order to ask to the grand jury or is excluded, because in Italy there are associations that can can charge the suspect. It is important because if we have as lawyers the possibility to charge and to go before the grand jury, we can make defensive investigation in order to reinforce the evidences against some people that I have individuated. And I think that the procedure, civil procedure, that I don't believe very much because another procedure has been rejected in December of last year by the judge of New York. Has established that victims they did not give the evidence of responsibility of 6 officers of Saudi Arabia. So I think that we can do a nice investigation and then we can go before the criminal, grand jury, criminal, not civil. I think that there are 2 kinds of grand jury. This is my idea.
Thank you, Judge. So, Mr. Sheehan, if you would help me interpret what the judge is saying or asking, is he asking whether we might, through some procedure, be able to present the case that the Lawyers Committee develops directly ourselves to the grand jury?
Well, he's suggesting that in Italy, that they have a unique system and that there are a number of associations that we might say are analogous, like the American Civil Liberties Union or the NAACP, that have a long-standing kind of reputation for doing these types of investigations, that they've been recognized as having the authority to come before an investigating magistrate who functions basically like the grand jury in Italy. And that's why this particular issue, one of the reasons the judge is here, is to look into that possibility, given the fact that there are foreign nationals that were killed from 90 different countries, and some of them are Italian. So that's another avenue that we haven't really talked about here at length. But what he's suggesting secondarily is that not to completely dismiss whatever conceivable chance there is to get a prosecution done, a criminal prosecution, but to pursue them in parallel, so that we move into the civil courts and to try the criminal courts as well, but not to delude ourselves as to what's going to happen when the prosecutors say no.
Understood. Okay. So thank you both, and I'll have some comments for both of your points at the end, hopefully briefly. But let's go from the far end. Mustapha, do you want to? Oh, sorry. All right, Mustapha, do you want to add your view on this?
Sure. It's a tough question. It's a tough question because of some of the things that I know about New York law, and we sort of generally know about the law itself. There are a lot of different tools that you can use that empowers the people, but as Danny pointed out, there are also sort of like impediments, and impediments are not necessarily legal impediments. They're impediments that come from the court system itself, from the judges or from the prosecutor. So I think when we have the next session, I talk about sort of the different steps of the federal complaint, the felony complaint in New York, and how you can take that before a prosecutor. You get a little bit of a better idea of what tools are available. But the reason why the question is a tough one is I think there's a practical element and then there's a legal element. I think if I was to answer just purely on the legal element, I would say, yeah, a grand jury is warranted. Based on the evidence that I heard today from the experts, this is the type of evidence that you can present to a grand jury. People just like you. I mean, I know that here we're preaching to the choir, but if this was an audience of people that would say are not awake, and they were to hear the evidence from the experts today, I feel confident that they would probably say, I feel like some crime has been committed. I don't know by whom, but something is not right. The official story is simply not right. So legally, I would say yes, a grand jury is warranted, but I think practically I would say no. And one of the reasons is, you look at the audience here is a very good audience, but we need an audience where this whole place is filled and you have people waiting outside to get in. I don't know who was here earlier when Bill Jacoby spoke about the civil rights movement and sort of the progression, the formation of the NAACP and the whole civil rights movement all the way until King. That took years and years and years before we got to where we did. But that also took like a swelling of the population. You can use any example. It doesn't necessarily even have to be the civil rights movement. It can be any example where you have basically a population of people that believe something that's just not true. And you have to convince them of the opposite. Once you get to that point where you cannot be ignored anymore, I think practically that's when a grand jury is more plausible. If you were to go to a prosecutor, he can't just sort of, just throw it to the side. And even if you got a prosecutor to actually present the charges to a grand jury, we all know, especially those who are New Yorkers, with some of the cases we've seen recently, the prosecutor basically picks what evidence they're going to present to the grand jury. If the prosecutor wants a true bill to be returned, they would do a pretty good job at presenting the right type of evidence. If the prosecutor does not want a true bill, they'll do a very sloppy job at presenting the types of evidence that they think would probably end up in not getting a true bill. True bill meaning that there's no indictment, the case is dismissed. Oh, sorry, true bill meaning that there is an indictment, the case is dismissed, and no true bill meaning that there is no indictment and the case will be thrown out. So, like I said, I think that, yeah, there are two considerations. One is sort of the practical one, which makes it very difficult to, I think, move forward to the grand jury process. But the legal one, I think, is very straightforward.
Okay. Thank you, Mustapha. And then we have Dave Meiswinkle. Do you want to offer your opinion on whether a grand jury is warranted or other actions?
Sure. I think it's at least a three-prong action. I just want to mention, too, as far as getting on a grand jury, you're chosen in New Jersey through your voter registration list. for a period of 16 weeks, once a week for the entire day. And also, if I didn't mention before, as regards to New Jersey's standing, the Port Authority of New York and New Jersey own the World Trade Center towers. I don't know if I mentioned that. Now, as far as a strategy, I think Danny Sheehan's is right. I mean, he's the mentor here as far as the civil action, but I think that there's a lot more that needs to be done, because I think most of us will be doing nothing, or we'll just be hoping that something happens. I think we have to make it happen. I think we have to live this Bill of Rights, make it come alive. So I think there's more that's necessary. What we saw today with the presentations made by the scientists, the engineers, the architects, Graeme, McQueen, is enough if it's packaged and given to people to just drop their mouths. They'll say, my God. That has to be put together, and it has to be presented to people. If you have to, and I'm willing to, go to every grand jury in New Jersey to try to get that to them through an assignment judge, even if it's a disc of some sort saying, hey, look at this, to get it going, or go down to Trenton and it'll interface within the Attorney General of the state of New Jersey. It's not been done before, and it should be done. All right, so we wanted to make the system work. It's rotten as anything. And we know as attorneys it's how rotten it is when you go against it. It is. But it's not totally rotten. There are some good judges. There are some good judges. And maybe we get lucky. New Jersey does have a district court in Newark, as I mentioned before. So that would be one of the avenues, the grand jury. The other would be the civil action. And the third one is what we want in New Jersey, and I think we all want, is a new 9/11 investigation. It was never done. Period. It was never done. And you've seen right at the beginning where the first lesson you learn as a police officer, preserve the scene of the crime. And all that valuable evidence, forensic evidence, was all shipped over to New Jersey and cut up and shipped out to Asia. I mean, that's just the beginning. There are so many fallacies here. It's almost a treasure trove for somebody to want to pick out inconsistencies. There is no truth to the report that they put forward. Now you've got the 28 pages forward, the JASTA bill that just was passed. You've got some momentum, and we're being taken seriously. So codify, put it all together, because architects and engineers are doing it, and what this presentation today was all about. Get that evidence to the attorneys. Let us run with it. We run with it differently: civil, criminal, and with the citizens group. Thank you.
Thank you, David. Thank you. Thank you all. Let me add my own comments before we move to the next session. I haven't really taken the time to tell you who I am yet, and I probably should, so you can interpret what I'm about to say. I am a public interest lawyer, 25 years experience, graduated from the District of Columbia School of Law, and I do mostly whistleblower protection, government oversight work, some environmental protection as well. And at first I want to respond to Danny's comments and say, first, I agree that the more likely course of action that will be productive on this issue is civil litigation. I do agree on that, and I think our organization is going to seriously look at that option. And I think the judge agrees with that as well. I agree with the judge that a parallel track may be synergistic, may be helpful to pursue a grand jury, to pursue a new government investigation, not necessarily expecting to have the problem solved that way. But there may be new evidence can be developed that way. Maybe public education can be promoted that way. Other benefits that may provide more force for our eventual civil litigation campaign. So I agree with that approach. I will bring to everyone's attention, if I can, no, I won't. So I'll read it to you. There is a federal statute, Title 18, Section 3332, Powers and Duties, talking about the grand jury. And among other things, it says the following: It's talking about any alleged violation of federal law. And Richard, if you want to help me, it's the very last slide of my presentation, very end. Thank you. So what this law says is that such alleged offenses may be brought to the attention of the grand jury, meaning federal, by the court or by any attorney appearing on behalf of the United States for the presentation of evidence. And that normally has been read to mean U.S. attorneys. It is not clear to me, and I don't know if Bill Veal is still here, but we are still looking into the question about whether the constitutional provision for a grand jury, which adopted the common law grand jury as it existed at the time, may give some broader options than the judges and U.S. attorneys are currently availing themselves of. One of them might be, Judge, that a U.S. attorney could decide to have assistance from a private attorney or a private group of attorneys in presenting a case to a grand jury. Personally, I believe that is within the authority of the grand jury or the prosecuting attorney. Has it been done? Not much, no. Might it be done? Well, that remains to be seen on how effective we are in doing our jobs. Now, this statute goes on to say something of interest. Beyond that, it says any such attorney, meaning any such prosecuting attorney normally, receiving information concerning such an alleged offense from any other person, let me emphasize, from any other person. So if the U.S. attorney were to receive information from you, from me, from our panel, if requested by such other person, if we request to the prosecuting attorney, then the prosecuting attorney shall, I emphasize the word shall, which is mandatory under federal law, shall inform the grand jury of such alleged offense and the identity of such other person who made that information available to the prosecuting attorney. Now, a grand jury, as I've explained, has the authority, if it were properly educated and so inclined, once it were told by the U.S. attorney that the lawyers committee, for example, presented a packet of evidence to the U.S. attorney alleging crimes A, B, and C, and who we were, the grand jury would be within its discretion and power to call us in to present that evidence directly to the grand jury. That's my view. My panel members may disagree with me. Okay? So that's all I wanted to say at the moment. And now we have a logistics question. My colleague, Mr. Bill Pepper, and I were conferring it. Now, break now or proceed. We're closer to being on time than we were. So, do any of our colleagues, Les, are you out there? And do we have your blessing to take a break? 5-minute break. We'll be back in 5 minutes. Anyone needs to take a break? Thank you.
5-minute break. Pretty depressing.
We are on a 5-minute break until approximately 1:50 p.m. Pacific.
We're keeping pretty close to their schedule. Pretty close to their schedule. So number 2 under litigation and advocacy in the United States, you are there. You are grand jury petitioning complaints. See, we've heard a lot of that stuff. I don't know
what we did is we filed petitions of the issues of writ of mandamus to Garrett.
It's not my area. I know, no. Ask him. That's a great question. Did you write it down? They're going to be little steps. It's not my area. I know. But this needs to be written down. It's a very good question given to William Pepper. He's sitting in his chair. No, you're right. It's a foothill. It's a foothill. write it down right now before. See, they're giving me questions right now. It's a very important question. Barb,
If you'll
We
take
are on a
your seat,
5-minute
we're
break.
going to begin.
It's going to begin now.
there with Mick. You're up next,
I
right?
don't know. Sometimes I don't know if this is working.
Oh, is there? There's just no slides before you because you're the next slide.
Could I have all the panel members, including you, Barbara, up at your convenience to the table? So anyone for the afternoon panels, come on up.
Please take your seats. We're being very efficient, making up for earlier lateness. Okay. Hello, everybody. I just want to take a couple of minutes to do some very important announcements. So this is something you're going to want to pay attention to. There's some news. Very, very important news. A presidential candidate has endorsed the concept of initiating a new investigation of 9/11. That is Jill Stein. Wouldn't that be an interesting impetus for the rest to respond? The others? Okay. Also, several acknowledgments. First, there's a lot of independent media in the House, and we appreciate and count on the independent media to cover this material that so much work has gone into and alternative research for so long. And two people in particular I want to give public acknowledgement and thanks to. One could not be with us yesterday, Gary Null. Big round of applause. WBAI, founder of the Progressive Radio Network. He was in Florida and due to weather problems could not make it up to be with us, but he has been a leading force for truth and courage in media, especially covering all manner of 9/11 topics. So thank you very much to Gary. Also, we have the host and founder of Guns and Butter in Pacifica, Bonnie Faulkner. Hey, Bonnie, she's back there. And she's recording all weekend, and you're going to hear a lot of excellent portions of the weekend on her radio show in coming weeks. Thank you so much, Bonnie. You have been a phenomenal force for truth and educational material that must get out there, and it does not in so many other places. So thank you for that. Lastly, folks, I think what you've heard today, even though there have been over the years some very good attempts to present legal analysis of 9/11 and the citizens' grand jury approach and so forth, what you've seen today here is completely without parallel. So, and I just want to put a major thank you to all the speakers. Many of them have come from far away, California, all over the country, and one individual from very far, the other side of the planet, Italy. So we are so happy and so honored and so grateful for everyone's presence and participation this weekend. And many thanks to the Organization of Architects and Engineers for 9/11 Truth. Richard, hope you're there. Yes. Many thanks to the phenomenal film crew, to John Kirby, Enrique, Daryl, and John's crew, Dan, everybody else, thank you so much. Thank you to Kevin, the sound and audio and lighting. Thank you, Kevin. And we appreciate it. Thank you to all the staff who worked so hard here to make this happen this weekend. And with that, I will turn it over to our esteemed MC, unparalleled William Pepper.
Thank you, Len. There are two questions that have been put forward. If there are any more written questions that you want to pass up here that I can address to the panel, I'm certainly willing to do that. The first question, panel, is does the President of the United States have any options or prerogative by which he or she could expedite or initiate a new forensic investigation?
The short answer to that is
your
yes.
discretion. Mike, Mustapha, Bill, whoever.
Well, yeah, of course. I mean, he's the head of the executive branch. He tells his attorney general to begin an investigation. That's it.
Yeah.
Well, it's pretty clear on that one. A new investigation could be done. And just to emphasize, even if a grand jury were to hear evidence and say, no, we don't want to present that crime for indictment, there could still be an investigation by the federal agencies from the president on down. Now, couldn't lead to an indictment without the grand jury's blessing. Investigation, no problem.
Okay. Mike, Mustapha, do you want to comment? Okay. All right, the next question is could the shareholders bring a suit against the World Trade Center and insurance companies for failure to investigate insurance fraud? They're all aware of the amount of money that resulted as a result of that catastrophe. So the question here is, there may be an insurance fraud issue, and the question is, should any of the existing, at the time, shareholders bring an action?
So I don't know if Danny wants to speak to that question. I'll repeat it for his benefit. Okay.
Actually, it's interesting. In the Wright case, you'll see that of the various law firms that are there, that some of them are representing some of the commercial companies who had their property destroyed in there. That Cantor Fitzgerald, for example, is in there. And I met with some of the family people, the victims' families last night, and they talk to the Motley Rice firm all the time. And so that there are big time commercial interests in that case. And so that the question of, as I've pointed out, expanding on what that case is. If people are talking about preparing a sort of a parallel litigation that identifies joint tortfeasors with whoever it is that they're going after, depending upon the theory of the case that is settled upon based on the evidence there are a whole series of additional causes of action. And then all you need to do is find a plaintiff from some of those other groups. So there are a dozen potential types of cause of action that can be brought once the legal team is assembled, and once the funding is available, once the kind of public education organization is in the field, once that becomes a real operation. And as you know, we've done a number of these. We did the Karen Silkwood case that took basically 10 years to go from the beginning to the end of that whole thing. We had to assemble all the investigators, all the public education people, the offices, all of the staff. We did the Iran-Contra case that took another 10 years. We did the American Sanctuary Movement, criminal defenses. We did there's a way to set up these types of operations, but that stuff has to be done first, and then you're going to discover that there's all kinds of sleeper causes of action that we may not have thought about already that can be included in that parallel case to supplement the more limited theory of the case that the Motley Rice firm is pursuing, because this could be one of those.
Can I just ask a question? How do you get around the statute of limitations issue there with regard the statute of limitations question when you're just talking about a commercial transaction?
Actually, because under the terrorism statute, there's this interesting little provision of the National Defense Authorization Act. We all talk about the National Defense Authorization Act of 2012 because it inserted section 1021 and 1022 that is being used as this potential dragnet thing. But in the National Defense Authorization Act of 2013, there was actually a provision put in there that extended the statute of limitations for any civil action that arises out of the 9/11 events. And it goes until January 2nd of 2019. So there's a looming statute of limitations deadline that is going to focus people's attention.
Let me add just a note on the statute of limitations problem. If you're looking at insurance companies or their members or their stockholders, the federal concealment rules might apply if you're talking about newly discovered evidence, and whether that would apply given the publicity that's been involved, hard to say, might. But if there's been a previous litigation and false evidence was presented and the case was closed involving insurance companies, it's possible that the new evidence being developed could lead to reopening those old cases on a fraud on the court theory. Very demanding legal standard to meet, but it is out there as a possibility. Just wanted to add those footnotes.
All of these more difficult standards to meet, such as the one you just raised, Mick, that they become much more viable if there's a number of people in the country watching the courts, because the courts all want to be able to maintain the impression to the public that they're functioning the way that they're supposed to function, like they've been taught in high school. And so that if you can get the American people watching, you'd be surprised how aware the courts are of what the right rules are. It's just that they don't pay much attention to them if they don't think an adequate number of people are watching. So that's the key to this thing. The grassroots organizing, the public education, the media activity that you engage in, et cetera. This is a law firm that you're talking about that has to have all of those capacities.
There was a case which, excuse me, involved Con Edison, and they were suing along with insurance companies, I think Larry Silverstein and others. And I just read some of the expert reports, and all the experts, they basically cited the official story. In other words, even when there was negligence, and the judge admitted there was negligence involved in the construction, or where they put the oil tanks in Building 7, etc. Even so, he said this was such a catastrophic event that sort of the negligence was out the window. We were in another ballpark. No one could have foreseen this type of event. So basically, he ruled against them. And the theory, I think, is so important. And the evidence that was produced here, that's not been brought before a court that I know of. This evidence changes the whole ball game. You don't have your experts then, at least like all these experts, going along with the official story and trying to make something happen within that official story, because that official story is blown out the window and now it's a whole different ball game. So.
Right. Okay. A number of questions have come up. One focuses on personalities, not surprising. And the question panel is, how come Bush, Cheney, and Rumsfeld have not been mentioned at all? I'm assuming that means have not been mentioned at all in terms of any potential liability.
Stay tuned.
So, yeah, let me just speak briefly. I mentioned earlier it's been an intentional decision on our part to not talk about suspects in this public proceeding. We may be talking about suspects in our filings. Others may have different views, but our decision was we're going to develop the evidence on suspects, present it to the federal authorities. If, and I hope this doesn't happen, but as has been stated, it may be likely to happen that once again the federal agencies don't pay attention. don't initiate a new investigation or a grand jury at that point, we're going to be in a different ballgame. And I think the gloves may be off at that point, and we may be talking more publicly, but probably not before we have developed and filed a civil action that we've been talking about. And I think, Judge, you had a comment you wanted to make on the prior question? Go ahead.
I think that it is possible to start invest the Italian jurisdiction as regard 50 Italian citizens, as happened for some crime. Trials has been started in Italy by Italian prosecutors. So I think that I can ask Italian citizens, families that are interested to start the prosecution to ask me to invest the Italian prosecutors in order to start the prosecution in Italy together with the
Thank you, Judge.
Okay, next. Was NIST negligent, and could there be any legal consequences of NIST's negligence?
I'll be glad to address that. NIST was way more than negligent. NIST was involved in scientific fraud. And, you know, they'd be way down the list of suspects in my mind in terms of time and energy and resources that you would put into getting them, but they were essential to the cover-up. So I gave up using the word negligence in regard to this case years ago.
Let me add just a note. To use a couple common phrases I'm prone to use. If it walks like a duck and quacks like a duck, probably a duck. This does not walk and quack like negligence. It walks and quacks like intentional conduct. There's also another famous saying from Arthur Conan Doyle through his character Sherlock Holmes that when you've eliminated the impossible, whatever remains, however improbable, must be the truth. And at this point, if you just looked, before looking at the evidence, if you just ask yourself, is it likely that this could have been an intentional act to destroy these buildings, most of us would probably say it's improbable. Being improbable doesn't mean it didn't happen. Doesn't mean it's not true. And I think what we've heard today, this is my personal opinion, from the scientists and engineers, you know, the laws of nature don't change from day to day. So I think we've eliminated the impossible. And what remains, even though it is improbable, must be the truth.
I think we have to, when we discuss NIST, we have to look at it, the chronology of the events. There was what happened on 9/11, all that crime, and we saw evidence today about it. And then there's what the government did to cover up in the reports, whether they be NIST reports or the 9/11 investigation or FEMA, whatever, federal reports. So it doesn't, you know, negligence is, we're not even talking about negligence or even criminal negligence. We're talking about intentional fraud and deception, fabrication, etc., of people who are very educated scientists and professionals, and they're spinning their story. So I think we have to keep in mind too, and even when we do our actions, they have a wall in front of the activities of 9/11. They've put this barrier up there. They're official reports. We have to take that wall down to get to the real action that happened on 9/11. So.
Right. I'm being pushed to move along here. There are two questions that deal with the International Criminal Court. The United States has not accepted jurisdiction of the International Criminal Court. Does any of the panel want to comment on any accessibility in terms of a European access?
Could you help the judge with that?
Could you repeat the question again?
Whether or not the International Criminal Court could be brought into the picture. The United States does not accept the jurisdiction of the ICC, but European countries do, and there were European victims.
There is the penal code, the Article 10, that allowed to Italian citizen families of victims of 11 September to start in Italy the prosecution because of the inert behavior by the United States prosecutor. And so I think that also in Great Britain, in French, you have the same possibility. I asked to International Criminal Court, I know that there are 65 British citizens victims of 11 September, and I know that a criminal code of Great Britain foreseen the possibility to ask justice for the victim who has been convicted, who has been murdered, who has been killed abroad. So if we can stay in contact, I think that we can start together a prosecution in Italy and in Great Britain. I am ready to do so, and I am in contact with you after we left.
Thank you very much.
Thank you very much. Thank you.
There was two last questions very quickly. One, Judge Imposimato has really responded to. It was a question that asked about Nuremberg principles and asked about the World Bank, which does not get involved in this kind of a situation. But Judge Imposimato has pointed the right direction, I think. And then the last question, I guess, is to everyone on the panel. I understand why we need to approach things in a different way, why we must work together for common goals. My impression of this panel is that they are fully aware of the necessity of working together and that there's no substitute for that. And I applaud the panel for that kind of unity. All right, now we may move on. The next item on the agenda is the legal campaign strategy. Now, the panel has gotten into a good deal of this already, and Danny Sheehan has made some significant comments on this. And I don't know how much more there is to say about it, but the thrust of the section has to do with not only national but international litigation. And I think Judge Imposimato has even just begun to address that and how to achieve greater transparency and justice for victims. And let's keep in mind the fact that the victims of 9/11 constitute people from all over the world, not just the United States. And so therefore that broadens the possibilities of and the venues for potential relief, which have not really been explored fully. And I think that's something, as Judge Imposimato has indicated, we should do, and Danny has indicated is a good way to go as well.
I actually had a question about that. Since the United States has not signed on to the International Criminal Court, doesn't that exempt all American citizens from accountability as a result of actions taken by that court? Did you understand what? United States citizens are not subject to jurisdiction in the World International Criminal Court. True or not?
I think that's a question maybe for the judge.
So
maybe Danny.
There's
International Court cannot be have not jurisdiction in this matter because they had started to judge the crimes, only the crimes committed after the 1st July of 2002. As this crime has been committed before, it is impossible. But in other case, it is possible. Now, in this case, the European can make directly the judgment inside the respective jurisdiction. In Italy, we have the possibility. In French, in Germany, and so in Great Britain, when there is an Italian or a British citizen who is killed abroad. And so I am sure, I have studied this possibility. We can ask, but this procedure requires the instance by a family of the people. If there are no instance, it is not possible. The families of the
victims,
the people killed in the Twin Towers, must present the instance to Italian judge or the Grand British judge. I will send you the model of this.
American citizens are subject to the jurisdiction of the Italian courts, as well as the rest of the European Union. The ICC is another matter, but we're talking about national courts here.
And the American citizen will have to get there, so that they'd have to get there. They'd have to be taken there.
It would have to be done.
Yeah,
it'll have to be done there. Okay. Does the panel? What does the panel take up? National, international litigation that hasn't been covered.
Right. Let's make sure we exhaust our panel's comments and questions on the international option. I have a question I'd like to ask the judge about the International Criminal Court and apparently the jurisdiction starting in 2002. Does that court? Hang on. Does that court have jurisdiction to look at concepts like aiding and abetting, accessories after the fact, misprision? Are those concepts recognized by the International Criminal Court?
The International Criminal, I met International Criminal Court 2 years ago in Venice because they were guests of lawyers of Venice, and the lawyers invited me, so I spoke with them. They wished to, but it was impossible because this crime has been committed before, so they cannot help us. They can help us only for the crimes that will be committed. We hope that it is not a necessity, but for other crimes, we can ask the International Criminal Court. As, for example, the crime of aggression that has been included in the Statute of International Criminal Court, as I told yesterday. So, if there is a state that this modification of the International Criminal Code was being signed by Germany, by Austria, by Spanish, by Belgium, 30, Italy, United States, and the Union Soviet, and China, they had not signed this convention that is in force. So this crime is in force. I suggest to indeed invite for the next year the International Criminal Court in here in New York, and to speak this. They are very kind people. My idea, I am a friend of this, and they can help us, but can help inside the rule of International Criminal Court. It should be a good idea. Anyway, this is very important, this meeting. I thank you for all your kindness and the help that you are giving for the justice, because without justice is no democracy. Without justice is no freedom. The state can exist without welfare, but none without democracy, and without justice, and without law. And I am worried because our state often are without justice and without law. In Italy and also in the United States.
We've been encouraged to move on, and we'll try to do that, but I just want to leave us all with a couple thoughts, which are questions to be researched. I can't give you the answer in the moment. I'll charge this to my colleagues in the Lawyers Committee to help me get the answer to. I'm wondering whether if a crime is committed before the date jurisdiction is available to the International Criminal Court, but a accessory after the fact or some follow-up crime is committed that's related after the 2002 date where jurisdiction is available, whether the criminal court might be able to look at the later crime and not the former crime. We don't need to discuss that further in the moment. It's a task for us to research. And the other point for my colleagues, and maybe for us all, is that we need to further investigate whether the crime of 9/11 wasn't the last crime in a series of offenses against human rights, but whether it might have been the first or one in the middle. And there may have been subsequent events that are similar, and some of those may have happened after 2002. And if they're related, and if they're the same perpetrators, there may be an avenue of inquiry there. I leave that for our future discussion, and I'll defer to my colleagues who want us to move on and turn it back to the moderator. But I think we're ready for the next panel.
We move on for any further comments related to litigation and advocacy in the United States. I think that has been covered fairly thoroughly, but if there are any further comments that any of the panel wants to make, now is the time.
We do have there a Freedom of Information Request panel, not all of whom are yet up at the table. Jane, do you want to join us? And is Doug McKenzie available? Now, Jane probably knows the answer to that. And I don't know if my colleague, non-attorney colleague, David Cole, is available by Skype. I don't know if anyone can tell me that for sure. Okay, so David is not with us. And that will save us some time. Let me just give David a plug here in his absence. David Cole is not a lawyer. He's an investigator. He's working with our Lawyers Committee. And by the way, you don't have to be a lawyer to be a member of the Lawyers Committee, so we invite others to join us. David Cole has been doing really good work on Freedom of Information Act requests for a number of years on this issue. I'm currently representing David in a Freedom of Information Act lawsuit against NIST and FEMA, the Federal Emergency Management Agency, seeking all of their raw data and original documents that they used in doing their building studies you heard so much about from our scientists. We've already gotten thousands of pages of documents turned over to us from that lawsuit already. It's not over, and we expect to get more. So I just want to use this opportunity, and maybe you can join me, because David will get to see this at some point, in thanking David for all his good work. So Jane Clark, our chair of the Lawyers Committee, has now joined us. Jane, do you want to make a few comments about our FOIA efforts?
Okay, well, we've got quite a few FOIAs going, but the one that I'm personally working on right now is a request to the Department of State on a Francis Xavier Taylor. He's a Francis Xavier Taylor. He's a brigadier general from the Air Force, retired July of 2001, was appointed by Bush to be an ambassador at large, and actually, before I go further on that, his whole career was essentially Air Force intelligence in one capacity or another. So I've asked the State Department to deliver to me the report that he gave to all the heads of state of the different countries that are in NATO that caused them to trigger this Article 5 that is essentially, well, NATO, they protect the members. If there is a threat from outside the country, they have to have a report stating how they verified that there is a threat from outside the country that would kick in and trigger Article 5. So I've asked for that report. It's still pending. I'm sure we'll have to go to litigation about it, but it's not at that stage yet. So that's where I'm at. Thank you.
Thank you, Jane. Does anyone else want to speak to FOIA before I add some closing comments? Just no, FOIA, the Freedom of Information Act. So I've been asked to do the obvious, and I agree, by my colleague to explain basically what FOIA is and how you use it for those who don't know. We sort of take it for granted. It's the law that allows every citizen of the United States to ask any federal agency for any public record, and except for a few exceptions, the agencies have to give you the records within a fairly short period of time. If they don't, you can do an administrative appeal to the agency, and if they don't respond to that in a fairly short period of time, you can bring a federal lawsuit in U.S. District Court, which we're now doing for David Cole on the NIST FEMA thing, and you can essentially compel the agency through the power of the federal court to produce those documents to you. It's a very powerful law. It's fairly simple. The case law has developed some ins and outs, but you don't have to be a lawyer to use it. So we encourage you all, if there's something you want to see from any federal agency, all you have to do is write the agency a letter, give your name, address, and phone number, tell them you're requesting documents under the FOIA, FOIA, and say exactly what you want. And that's all it takes to get it started. So let me add just a note from my own experience using the FOIA. There's a group in Bloomington, Indiana, the Bloomington 9/11 Working Group, and we did quite a few FOIAs, Freedom of Information requests over the years, and they produced some surprising information, and I only have time to give you one example. We got a document back that showed that one of the hijackers, or at least one of the supposed hijackers, had applied to renew their pilot's license and been subjected to a medical exam after 9/11. So just think about that. I'll let you dwell on that. But there are a lot of documents you can get through FOIA that really beg some important questions. That's just an example. So I think we're ready to go to the next subpanel, which is the grand jury petition and complaint procedure. We've covered most of that, except I told my colleague, Mustapha, to not explain that procedure in his earlier presentation. So now I'll give him a moment to explain the New York procedure now.
Sure. Before I get that, I just want to comment on the FOIA. There is New York, for those people who are New Yorkers, has sort of like a correspondence statute, FOIA. So you can also requisition documents from government agencies in New York. And some of the FOIA provisions actually, there are two cases that are litigating government responses to two individuals who made FOIA requests who have been denied documents that they requested. Now, turning back to the grand jury, so in terms of who can convene or who can request or requisition a grand jury to be convened, there are only 1, 2, 3, 4, 5, 6, 7 states where individual citizens themselves can cause a grand jury to be convened without the filing of court papers. That's Nevada, Kansas, New Mexico, North Dakota, Nebraska, and Oklahoma. And actually Oklahoma, after the Timothy McVeigh case, there was a grand jury that was convened to investigate whether or not there was like a wider conspiracy. And this is done by petition. I forget the numbers of people that you need to have the petition signed, but once you have the prerequisite number of people to sign the petition, then the citizens basically themselves can cause a grand jury to be convened. That's not the case in New York. In New York, although people have, like the New York Sovereign Citizens Group have tried to have their own sort of convening of grand juries, it's not a legal process, it's not recognized. But in New York, how the grand jury system sort of works is you can have the prosecutor can convene a grand jury. You already have the pool of the unfortunate souls that got the letter in the mail telling them to have to show up for grand jury duty. So they show up and then they get picked. So from that group, the district attorney's office can convene a grand jury and issue something that's called like an ex-indictment. So some of this might be a little confusing, but basically an ex-indictment, what that means, my time has run out, but I'll try to be very, very quick. What that means is normally in order to have a felony complaint, in order for somebody to have to be brought before a grand jury, like a case has to be brought to a grand jury, you have to file the complaint in the court, in a local court. And then from the local court, that complaint goes to a superior court. And then at the superior court, you have a grand jury impaneled, and then they will hear the evidence. However, there's another process, usually that happens in cases like where there's sex crimes, where you don't want the victim's name to be known. The district attorney will impanel the grand jury without the filing of a case in the lower court, have the grand jury hear all the evidence, and then basically move the case forward. But otherwise, the only way that you can pretty much get a grand jury going is by filing a case in a lower court. Two sort of quick things for you as citizens is that in New York, legally speaking, remember before I was talking about legal versus practical, legally speaking, the criminal law section 100.10 allows you to file a criminal complaint against someone that you believe has wronged you. Actually, it doesn't even have to be filed by the person who has been wronged. It can be filed by someone who has knowledge of the crime that has been committed. Practically, how does that work? I actually tried to test it out. I had one of my friends, a friend of a client, try to test it out by going to the New York County Criminal Court and also the Kings County, which is Brooklyn Criminal Court. I didn't go myself because, of course, I just don't want to have to then explain to them that I, as a lawyer, don't know exactly how to do that, because it's very difficult to actually do it. And not many people know how to do this. So this friend, he went to the New York County Criminal Court and told them, I have this statute that I know about that allows me to file a criminal complaint. How do I do it? The person basically told them to go fly a kite. And that's a kind way of saying what the person told them to go do. So then I asked him, well, why don't you go to Kings County, Brooklyn? They're a little bit more liberal than Brooklyn. Maybe they'll allow you to do it. Same response. Nobody has ever heard of it. What are you talking about? File a complaint? Go to the precinct and file a complaint. We were trying to figure out a way that you can file a complaint without having to go to the precinct, because the person explained to them that his complaint was actually against a police officer, so he didn't want to go to a precinct. Nonetheless, he was told there's no such method by which you can file a complaint on your own. But on the books, legally, you are allowed to file a complaint on your own. So there's one sort of final thought, I'm pretty much done, is, well, again, for all the citizens here, you yourself, this has nothing to do with grand juries, but just a final thought, because I think it's important for people to understand, since we were talking about the Bill of Rights, the rights that people have, not just in the Constitution, in the US Constitution, but also in the New York Constitution and New York statutes. You can bring a case for petty crimes like assault in New York. Let's say I've been assaulted by somebody. I can go and file a complaint. Not only can I file a complaint, but I myself can prosecute the case. That's a shocker to a lot of people. It was a shocker to me to learn about this. So anyone here that ever gets into a fight with someone and you feel that you go and complain to the prosecutor and they're not doing something, it may take a lot of work, but bring the case yourself and, if possible, prosecute the case yourself.
So we have one quick FOIA addition. We had another speaker, Doug McKenzie. We got some technical problems plugging him in. So Jane Clark will summarize what Doug is working on the FOIA, and then we'll go back to our next panel and to our moderator and proceed with our agenda. Jane?
Doug McKenzie is one of the attorneys that we have out in California. He was a patent lawyer. He's been doing an insider trading SEC FOIA action. And what we know pretty much so far, and there was initially a newspaper man that had done a FOIA on insider trading shortly after 9/11, and the SEC says we have nothing. Then actually David Cole had done FOIA on insider trading, and what we came up with was correspondence between the SEC staff and the 9/11 Commission staff, what kind of upset us was that the 9/11 Commission staff made a deal with the SEC that any documents that they reviewed from international means that they were going to review for the purposes, was there or was there not insider trading before 9/11. They made a deal with the SEC and their clients that you couldn't FOIA those documents. And if you didn't FOIA, then you could possibly get those documents through a court proceeding. But if the court proceeding was going to proceed and they were going to be subpoenaed in some manner, then SEC would notify, the 9/11 Commission would notify SEC so they could notify their clients before any of that happened. So we do have the one attorney, Doug McKenzie, doing the FOIA action on that, and he's close to finishing his appeal since the documents are very lacking still, and going to court on that. Now, I do know also David Cole, and he's got a lot of technical FOIA actions that relate to things that the engineers and the architects need that he's working on. He's got about 19 or more right now. So these all have to go to court, and they all have to have attorneys taking them to court. But I do know those are his deal with NIST, FEMA, and trying to gather evidence for Richard Gage's group, really. Thank you.
Thank you, Jane. So before I turn it back to Bill Pepper to proceed with our agenda, let me just make a note for those in the audience who may not know the background on why the Securities and Exchange Commission is relevant to 9/11. The put options issue, some of you may have heard about. There were some yet to be fully identified parties who engaged in some suspicious transactions on the stock market just prior to 9/11 involving millions of dollars worth of put options. And a put option is basically a bet that a company stock will go down, not go up. And those bets were placed on companies heavily involved in 9/11 in terms of being victims of 9/11. Two of the airlines that were involved, I think one of the companies that had a lot of offices in one of the buildings that was destroyed. And so the 9/11 Commission looked at that and thought it also was suspicious. But then the commission dismissed it by saying, well, we looked into it and the people who placed the put options didn't seem to be connected to the 19 terrorists, so we didn't go any further. So that's why we're doing a FOIA. I just wanted, for those who didn't have that background. So Mr. Pepper, I'll turn it back to you.
Mick, if I could say one more thing. There was a $5 million put option gain that no one ever did collect.
Right. Nearing the end, the significant issue of the 28 pages has been around for quite a period of time. Barbara Honegger and Mick Harrison and Les Jameson will air that for us.
So give us just a moment to do musical chairs and we'll start. And Les, do you want my seat? So, well, okay. Do you want to go first or does Barbara go?
Barbara.
Okay.
Okay. We'll need the slides for Barbara and myself.
So we're going to start with Barbara Honegger, and then we'll go to Les. And if there's anything less to be said, which may not be the case, we'll go to me.
We are at a critical turning point in history, what Winston Churchill called the hinge of history. We all know it, we all feel it, and what is happening right here in Cooper Union Great Hall on the 15th anniversary of the horrendous attacks of 9/11, where Abraham Lincoln gave the decisive speech that led to his nomination for president, is such a hinge of history. My fellow Reagan administration executive department official, Paul Craig Roberts' article for this 15th anniversary is titled, "The Tide is Turning." The official story is now the conspiracy theory. The 28 pages have finally recently been released after 14 long years of cover-up. The Justice Against Sponsors of Terrorism Act, JASTA, has passed both the House and the Senate unanimously just Friday to thunderous applause on the floor of the House of Representatives. This is truly a hinge of history. When President Obama signs it, or when Congress overrides his still threatened veto, the reportedly 9,000 9/11 victims' family members of the attacks, their legal case against the Saudis for their claimed complicity in supporting the alleged hijackers, and more on the word alleged in a moment, will finally be able to go forward in the courts. Now, you are absolutely going to love this. But Terry Strada, who is the spokesperson and lead spokesperson for one of the major 9/11 victims' family members groups, when she was asked, well, wouldn't this be horrible for the United States? Because if after all, these victim family members can sue the Saudis, well then Saudi citizens could turn around and sue the US government. Amen. You know, but not just Saudi citizens, but citizens from any other country. And her precious response was, well, that shouldn't be a problem for the United States as long as they're not committing terrorist acts and killing people around the world. All right. So we heard here yesterday, and I saw all of yesterday online, we heard here yesterday from my 30-year colleague from our Iran-Contra Truth Movement days, Daniel Sheehan, call the September 11th attacks one of those high crimes that caused the very foundations of the law to tremble. And indeed, you may not know that a member of the Parliament of France, who is the equivalent of our chairman of the Senate Foreign Relations Committee, said after the unanimous House vote for JASTA that if JASTA becomes law, it will, quote, cause a legal revolution in international law, unquote. That is the unanimous passage of JASTA, 100-0 in the Senate and 435-0 in the House of Representatives just last Friday, is already causing the very foundations of world law to tremble, not just United States law. We are truly at a hinge of history. And as Danny Sheehan also passionately reminded us yesterday at the end of his presentation, once the jury realizes that they have been lied to and deceived by the other side, they turn and that it is our job that we have taken on here today to bring the American people, indeed the public of the world, to that turn. So now I'm going to go to the 28 pages, which, as we all know, their release was absolutely instrumental in the unanimous passage of JASTA by both the House and the Senate, and I fully expect JASTA to become law. But may I just make explicit that the most magnificent thing about JASTA, if it becomes law, and I expect it to, is that when it does, it's not just the Saudis. And there's a problem with the case against the Saudis I'm going to get into. A big caution, a big red flag, but even though we need to move forward on it. But JASTA would allow the citizens of any country, any foreign country, unfortunately not our own, which is the most important, but any foreign country, to sue the United States for the citizens of any foreign country to be sued by United States citizens if there was credible evidence that the government or its agents of any foreign country, any non-US country, were involved in planning, carrying out, covering up any aspect of a terrorist attack against United States citizens on our own soil. And of course, 9/11 is the premier example of that. So now I'd like to I'm going to quickly go through the 28 pages. Are the 28 pages really the Saudis' nose in the 9/11 truth tent? We do need to move forward with it. We are moving forward with it. JASTA, I believe, will pass, and the almost 9,000 9/11 victims' family members will almost certainly have their day in court and discovery with under oath testimony, subpoena power, etc. But the problem is that the Saudi support for the hijackers assumes the official story. And as we all know, there are huge holes in the hijacker story. Paul Grake Roberts, just the other day, with whom I served in the Reagan-Bush Senior administration, wrote in an email, quote, "I would caution you about the Saudi Arabia angle. The Saudi thing actually works against you." I can't go into all the details of that, but I agree. Former Senator Bob Graeme at the National Press Club just August 31st said, the release of the 28 pages is removing that cork from the bottle, that he hopes and believes that once the 28 pages was released, which it is, we've already seen JASTA pass unanimously in both houses of Congress, he is now explicitly calling for at least the FBI and the CIA and all aspects of the United States government to release all still classified documents on 9/11, and that absolutely has to happen. I do want to point out that there are still redactions in these declassified 28 pages and released 28 pages. And you can be certain that these redactions, and there are still quite a few of them, are extremely important. So what we need, as we did for the 28 pages, is, and our heads are cut off here, but we need a Mike Gravel for the 28 pages. Now, this photograph was taken at this conference last year when I went up to Mike Gravel and I said, "Mike, your country needs you. We need a Mike Gravel for the 28 pages." And I will never forget the moment. Makes me cry just to remember it. He said to me, I got it half out of my mouth, and he knew where I was going. And he said, "Barbara, I see where you're going. I'll do it. I'm an old man. This is my mission. I will make it happen." And I'm here to tell you that thanks to this man, Mike Gravel, who read the Pentagon Papers on the floor of the Senate in a Senate committee and got them released and got Gravel versus US through the United States Supreme Court, a magnificent feat. He was also very instrumental in getting the release of the 28 pages, and so was my colleague, Mick Harrison, and I must say myself. Just a few tips of the iceberg, literally, of the 28 pages. As those of you who have read them, You will know this, but if not, please do read them. They are now in the public domain on the internet. There are 17 references in these very few 28 pages to Prince Bandar, who was the Saudi ambassador to the United States on the day of and after 9/11, so close to then President George W. Bush that he called him Bandar Bush and his brother. And also Bruce Rydell, it has recently been reported, who is a top terrorism expert formerly for the CIA and Rand Corporation. Bruce Rydell said that Bandar Bush was so close to President George W. Bush that he not only called him Bandar Bush, but according to Rydell, that Bandar Bush was in the White House sometimes every day during the administration. We know that Bandar Bush, we have a photograph here from, I believe it's September 13th, 2001, just a very, very short period of time after the attacks. There is Ambassador Bandar Bush, President Bush, Vice President Cheney, Condoleezza Rice, and one other unidentified person on the left on the White House balcony, where it has been reported by Barry Kissin, who is also a magnificent 9/11 truth activist, researcher, and writer. Barry Kissin has reported that they were having a congratulatory cigar after the 9/11 attacks on the White House balcony. This is, I'm good at text, but I'm not really good at photographs, so I always cut the heads off of my photographs. But this is Zacharias Moussaoui, who was alleged to be the first alleged 20th hijacker. And it's important for you to know that many of the same names, when you read the 28 pages, many of the same names of the very high-ranking, not only Bandar Bush predominantly, but also others, high-ranking Saudi royals and other top Saudis, that there are many of the same names in the Moussaoui deposition. And if you haven't read the Moussaoui deposition, which I believe was done for the case of the 9/11 victims' family members against the Saudis, it is a must-read. It rings completely true to me, and it is truly an eye-opener. And also, many of the same names overlap with the deposition and revelations of Birkenfeld, in the Birkenfeld documents from the UBS Swiss bank whistleblower. But here we get to the real rub with the whole Saudi connection in the 9/11 victims' family members case that's almost certainly going to go forward. Bandar Bush not only was one of 22 Saudi officials mentioned just in the 28 pages. However, what's important is that those 28 pages, as far as I can tell reading them, only really refer to 2 of the alleged 19 hijackers, of which we know 15, according to the official story, are allegedly Saudis. And both of those hijackers, alleged hijackers mentioned in the 28 pages, are both on the alleged Pentagon plane, not any of the other planes, just the Pentagon plane. And one of the big problems is that one of those 2 hijackers, Al-Midar, was one of the very first of the at least 6 and as many as 10 of the alleged 19 hijackers to have been reported still alive after the attacks. As Mick mentioned, one of them, he's even got a FOIA document about one of them after the attacks being alive. I'd like to know, Mick, if it was Al-Midar. But in any case, you can imagine what would happen in a Perry Mason moment in this incredibly important case that is going to hopefully go forward with the 9/11 victims' family members against the Saudis, if in their defense they came into court in a Perry Mason moment with one or more of these still alive alleged hijackers. What would that do? And I have to tell you that I feel a setup here. So that we just need to move forward with caution, even about that case, once it goes forward. And I'm going to skip over these slides. They are actually in my DVD Behind the Smoke Curtain on YouTube that now has over 300,000 views. There were no hijackers on the Pentagon plane. Couldn't have been Flight 77. You will see that in behind the smoke curtain. This is just an example. This is where they were allegedly coming through Dulles Airport. Doesn't have a timestamp, and it's the wrong number of frames per second for a security camera. There's official documents from Indianapolis Air Traffic Control that was sent to FAA headquarters proving that the plane that left Dulles was not the same one that went back east, and therefore couldn't have been the one that approached the Pentagon anyway. And this is Mr. Al-Midar. So Mr. Al-Midar is one of the alleged two hijackers that are the only ones mentioned in the 28 pages. So the 28 pages is problematic, and even though we are going to move forward, we have to do so with a serious red flag and caution. Now I want you to read this slide carefully. You're either with us, George Bush says, or you're with the truth movement. Okay, now why is, this is like the last two slides. The Saudi Bush link, the real red flag is that the Saudi Bush link, because it's so close, especially between George W. Bush, who was president before, on, and after 9/11, and Bandar Bush and all those other Saudis and the entire Bush international crime family. The problem with that close connection is that if you have that Perry Mason moment, bringing in some of the still alive alleged hijackers into the suit by the 9/11 victims' family members into court, once they get there, it's almost certainly in the court of public opinion, with the mainstream media pushing it, is going to let the Saudis off the hook, and we don't want to let Bush off the hook. But if they're joined at the hip, both might happen. So we have to be very, very careful if we want to bring the real perpetrators to justice. Thank you.
I'll sign up for that guy's army. Okay. Here we are. I have 3 slides to share, and I just want to recap this one from yesterday, folks. Being that this is the day of legal justice in focus, with the 28 pages, these 2 paragraphs, I think, should draw everybody's attention, where we have the highlights on references to an FBI informant and an FBI asset right there in the 28 pages. I hope everybody will download them and study them, read them. It's very important and stimulating reading, I must say. And so with this acknowledgement of, within the report, this official report, where we have an FBI informant and an asset, what does that translate into? That's inside job. Very close, and I think without too much effort can get to the full indictment of inside job. Now, also within the 28 pages, I noticed some very big contradictions. There are some references saying that FBI had not been really conducting any investigations into any Saudi activity for quite some time, prior to 9/11. That is equivalent to Condi Rice saying, we just had no idea anybody would think to fly planes into buildings. I'm working on a timeline here. Look at this. Going back to 1993, World Trade Center bombing, government charged Sheikh Omar Abdel Rahman with plotting to set off 5 bombs in 10 minutes, blowing up the United Nations, the Lincoln and Holland tunnels, the George Washington Bridge, and federal building housing the FBI. 1993. Also, the same year, Ramsey Youssef was reported to have assembled a bomb to be used at the World Trade Center. 1993. 1995, Operation Bojinka, large-scale three-phase attack planned by Ramsey Youssef and Khalid Sheikh Mohammed, including crashing a plane into headquarters of the CIA. Again, think of this, in the 20 pages, they're trying to say, the FBI is trying to say, oh, we just had no idea this was going on. Okay? 1997, Saudi intelligence arrested Khalid al-Midar and Nawaf al-Hazmi. These are the same two mentioned in the 28 pages, being facilitated and set up in San Diego by Omar al-Bayoumi and Osama Bazlan. They were arrested as they attempted to bring weapons into the Kingdom of Saudi Arabia. From that point on, the kingdom monitored the activities of these known Al-Qaeda operatives. Okay? This is very incomplete, folks. This is just a start in this timeline. Then in 1999, and this is mentioned in the 28 pages, a character by the name of Mohammed El-Qurayin attempted to enter an America West cockpit on a flight to Washington, D.C. to attend an event there at the Saudi consulate. So picture this, right? This guy attempted to enter the cockpit, and it was thought by some investigators this was potentially a dry run of trying to work on the plot on the operation. And so there was all kinds of research, investigation going on, surveillance prior to the 2001. And so for the FBI to say, and any other intelligence agency to say, we just didn't know, didn't have enough to piece it together, that is patently false. And well, and this also, we have to add into the efforts of Richard Clark and what happened in terms of him being demoted as czar of terrorism, which indicates that any effort made, let's also add in the whistleblowing efforts of 3 FBI agents, Colleen Rowley, Robert Wright in Phoenix, and Harry Samet. By the way, in the 20 pages, it does mention warnings being given by an FBI agent in Phoenix, and I'm sure this is reference to Robert Wright. So there are so many indications that if you accumulate them all, that what does the evidence of this accumulation add up to? Obstruction, conspiracy, and I think these are all points for a legal case, and I'm presenting them as legal strategy, legal analysis. And there's one more right here. The John O'Neill, Special Agent Counterterrorism Expert. There's a whole list of his investigation going on until from 1995 right up to 2001, or I'm sorry, 2000. And we're talking for instances, for instance, he studied the 93 bombing with Ramsey Youssef, the 96 bombing of the Khobar Towers in Saudi Arabia. He continued to warn in 1996 and 97. He continued to warn of growing threats of terrorism. In January 1997, he moved to New York to be special agent in charge of the FBI's National Security Division, the FBI's largest and most prestigious field office. And so there's much more here. And I think, compelling conclusion with the 28 pages and with this, evidence in this timeline, which is just a start, like I said, I think we're seeing the blueprint of major part of the plot of the cover operation, and which is so significant because we're seeing part of the actual conspiracy right here. And so we're in a new phase with the release of the 28 pages and also with the passage of JASTA unanimously, with the now stepping up of the legislative leaders and former Congressman Bob Graeme making statements how this is just an intermediary step. The cork is just out of the bottle. Now much more is going to flow. He has said that if the case moves forward, what will be brought forward in terms of additional evidence will be astounding. And so where does that leave us now in the coming weeks and months? We have a lot of work to do, and we have a huge opportunity, phenomenal opportunity. Wouldn't you want every media source? Wouldn't you want all your legislators? Wouldn't you want the White House to know that there is a majority of people in this country who knows that 9/11 was an inside job and demands full spectrum truth and justice? Wouldn't you want that to happen? Okay. So this is unprecedented, and at hr14.org and 911tap.org, we have the grassroots efforts, the national organizing to carry this forward. Thank you very much.
So let me just add a final comment on the 28 pages, and we'll turn the proceeding back to Bill Pepper. I did have the privilege of drafting a law review article regarding the 28 pages, thanks to Bob Honecker, who twisted my arm and told me to look at the issue. And I did. And the more I looked, the more I was concerned about what was going on. So I'll just give you the short version. The law review article that I wrote, even though the law journals I submitted it to didn't jump to publish it, thanks to former Senator Mike Gravel and Walter Jones and others, it did get an audience in Congress, a pretty wide audience. And the gist of it was two things. One is, under the speech or debate clause, every member of Congress has the right, during a congressional proceeding, which could be a hearing or an investigation, a report, etc., to disclose any information they consider relevant to the congressional proceedings, even if it has been classified by the executive branch. Now, Senator Mike Gravel did that back in the era of the Vietnam War, possibly saved my life at the time. He doesn't know that because I was a conscientious objector to the Vietnam War, but was willing to go as a medic. And I was 1AO at the time when the draft ended. So I thank Mike for that. But Mike, back in that era, disclosed the Pentagon Papers, even though they had been classified by the executive branch. And he had every right to do that under the speech or debate clause. And not every Congress member understands their rights to do that. So we've been trying to help inform them. And it may be an ongoing issue. They may have other opportunities to do this, even regarding some of the redactions on the 28 pages. So that was one focus of the article. The other focus was the journal clause of the Constitution actually requires Congress to publish its proceedings for the benefit of the public in every instance, with one exception only. And that is the Congress can choose to not publish some part of its proceedings only if Congress itself determines that there's a need for secrecy regarding that particular matter. Now, what was little known about the 28 pages until recently, and perhaps with our help, was that it was the executive branch who decided that there was a need for secrecy regarding the 28 pages, not the Congress itself. The Congress had actually, the two committees of Congress who wrote the report, when they transmitted it to the entire Congress, they actually said, we're going to ask to have these 28 pages declassified. So the committees that actually determined the opposite of a need for secrecy, they determined there was a need for public disclosure. Now, that was, of course, correct. The problem was they didn't seem to understand that once having made that conclusion, the Congress then had an obligation to publish those proceedings because Congress had not determined in its own opinion that there was a need for secrecy. So we suffered under that secrecy imposed by the executive branch illegally, unconstitutionally for 14 years. And now recently we've had some success in getting the bulk of those 28 pages released. That's all I wanted to say, and I'll turn it back to Bill Pepper.
Thank you, Mick. Barbara and Les, thank you for that update. Thank you very much for the update on the 28 pages. And it's an essential way to close this wonderful gathering, and very important. Thank you. Thank you all for your patience and your concentration through some very technical and difficult material that's been presented here today.
We have one left.
Which one do we have left? I thought we were.
I know, it's hard to believe. It's the catch-all panel for U.S. litigation strategy. We just have some sort of closing comments there.
Which one do we have left?
U.S. litigation strategy.
Litigation?
So this is the strategy for going forward. We haven't really unpacked that fully yet, even though it might seem like we have. So we'd like a few more minutes, Bill, if you could tolerate that. Yeah, we have a few comments from some other folks. Danny, Dave, Bill Veal, if you're still here.
Yes, I'm here.
Okay, thank you, sir. And I think the judge has departed, has he? Has the judge left? He's welcome to come back if he's still in the room.
My notes disappeared. Now they're back. Okay.
I just have 1 minute. Hello, hello. No? Oh, here we go.
Okay.
Yes.
So we're going to go to U.S. litigation and future investigations.
Bill, excuse me 1 sec. Just because we won't have a chance for this after. We have the rest of the panels. Tonight, up till midnight, Gary Null will be playing a 6-hour 9/11 special. I've been asked to announce that. Yeah, but we're not leaving until after 6. It is after 6. So when you go home, go to prn.fm, and it may be on WBA, but I'm not sure. Yes, his website will be streaming, prn.fm. And folks, please help us by leaving this place as clean as possible when we leave. And that'll, and also I could ask for 2 to 3 volunteers to help us break down afterwards. And let's see, was there anything else? I think that's it. Again, thank you to the speakers and also to you, the audience. I know we have somebody here from Sweden. We have 3 people from Australia. And I know we have people from all over the country. Thank you so much for making the trip, for spending your weekend with us to be part of this historic event. I couldn't stop without that.
So we want to do this in a particular order and remind our folks we're trying to be concise so we don't keep folks too long. So I want to start with Danny Sheehan again. And Danny, if you have any further observations on either U.S. litigation strategy going forward or possibly future investigations, this is your moment.
So yeah, as I open our discussion here this weekend, I think that what we need to do is view what is happening here as a Rule 11 investigation, a full-scale professional investigation conducted by attorneys to determine whether or not there exists, so that it can be presented to the court in the original complaint, even though the complaint requires only a bare bones pleading, setting forth the general facts. The reality is there's going to be an extraordinarily high standard of specificity that's going to be required in order to avoid any federal district court from dismissing the case out of hand. As Bill has experienced, you know, they'll consider it some kind of a paranoid fictional fantasy unless you dot every T and cross every or dot every I and cross every T and put the details in front of them. I think that under the Terrorism Act, the civil provision of the Terrorist Act, Title 18, Section 2333A, specifically authorizes private attorneys to go forward to take the place of a prosecuting attorney if they don't do anything about this. There is the provision that you have raised in the past, Title 18, Section 3332, that seems to impose a mandatory obligation upon a United States attorney if an adequately prepared professional petition setting forth the same type of detailed information is presented to her or to him. They're required to present that to a grand jury. But the reality is that we need to keep our eye on this anti-terrorism provision. And that is the statute, the principal statute under which people need to proceed. And there needs to be a full-scale professional investigation to prepare the case almost as though it were ready to go to trial by the time it gets presented to the district court, because they're going to do everything they can to keep people from having discovery. Okay, so that's what I think people ought to keep our eye on, and emphasize again the fact that the case, no matter how solid your evidence is, no matter how clear the law is, that it's going to require a major grassroots organizing and public education component in this, with an outreach to the major media. This has to be done. It's the only way that the two major political parties in the United States today will be disempowered from stopping such a case from going forward.
Sir, thank you. So let me go to Judge Imposimato one last time for the day, and let me introduce to the judge sort of why I'm hoping he will speak to, even though we're talking about U.S. civil litigation, not Italy, just want to make that clear, but nonetheless, I want to let the judge know that I will be recommending to my colleagues that we make ourselves available to the judge to assist him in any international effort if he will agree to help us in any U.S. civil litigation effort.
And I hope to continue with you this wonderful experience. I am sincere when I say that for me it was very important, this experience. I will tell my as I have known very intelligent and courageous people. I hope to commit you also in the fight in order to convince some people to introduce in their ordinament, in their statute, the crime of aggression of the state. That is included in since 2 months ago. Yes. It is a battle that we have to do, because if Germany signed this convention and this crime, it is a part of the statute of International Criminal Court. We have to fight here in the United States, in Italy, because in Italy they must fight to introduce this crime, because some people want to involve Italy in the fight against Iran, and as some people involved Italy in the fight against Iraq. I think that I know as the president of government Italian answered me today because I spoke about the danger of a new war. Do you know this? I have been informed today that after I told that Italy can be involved in the war, in the possible war against Iran, because some people of the United States asked to non-confirm the nuclear agreement signed by Barack Obama. Ms. Michael Flynn, General Michael Flynn, told that if Trump will win, he will ask him to not confirm this nuclear agreement. I am worried because this is the way to start the war against Iran. Because of it. And so I think that the possibility to say this problem that involve the peace all over the world, because the problem of terrorism is connected with the problem of the war. The terrorism is used in order to make the war. So I thank you very much, because the yesterday commitment of together is involved, has been the occasion for the president of the Italian government to attack me and to answer with me, because I am against the reform of Italian constitution that is right constitution. And they want to change the article concerning the declaration of the war. So this is very important result for us, because of the problem of the war no es el personal of the Imposimato of other people that this important commitment. Quindi I thank you very much, and we have to prosecute this battle against the idea to not confirm the nuclear accord, and sustain all the candidates, also the candidates that are committed in continued the agreement with Iran, with China, with Russian, with all the people, with Germany, Europe, all the people that are in favor of the peace against the war. Thank you very much.
Thank you, Judge. So let me go to my colleague, Dave Meiswinkle, to my right, and see if Dave wants to add thoughts about future litigation or future investigations.
We do realize that the evidence today, most of it was about New York City, and fittingly so, because the really good studies have been done here on the high rises, the forensic evidence, at least the scientific evidence analysis we saw from numerous experts today. But that wasn't the only area. The Washington, the Pentagon, which Barbara Honegger has done a lot of work on, very important area. And the Shanksville alleged crash of United 93 out of Newark, very important too. Less study has been done on that. I know Mark Gaffney's written some books on it. In those areas, I think, in all the areas, we need more investigation. We need more FOIAs, the Freedom of Information Act. And some of those lesser attended areas, you might find something very important to connect it all together, because this is a grand conspiracy. And what I've outlined here, those areas, there may be areas that they weren't successful in, whoever did it. We may find out that there were other things planned that didn't come off, thankfully. So I think we all have to keep in mind that there was an attempt to hijack our country, in a sense, with the Patriot Act, the Homeland Security, the National Defense Authorization Act, the indefinite detention, the drones, the torture, the NSA, the TSA, the wars in Iraq, Afghanistan, etc. That's not the American way, at least not the way we want to look at our country and reflect on it. So I think it's very important to realize that the Bill of Rights behind us, there was some controlled demolition there. It wasn't just buildings that went down or they wanted to bring down. They wanted to bring our country down, our freedom down, our spirit down. They wanted to bring this document down, the Bill of Rights in our Constitution. That makes us be Americans and different. This Bill of Rights could go everywhere in the world freely, and I think most people accept it, would be gladly accept it. We have to preserve it, and that's what we're trying to do. So thank everyone for being here. Please continue it on. It's been 15 years, but it's a growing movement, and it's a growing movement about what it is to be an American. We have to really redefine that, and we can redefine it by going back to our roots. Thank you.
Thank you, Dave. Let's go to my colleague Bill Veal on the far right, and then we'll come back to Barbara.
Assume this is working. Most lawyers, when they get invited to speak or come to talk about their resounding victories, and I am here because of the resonance of my legal obliteration. I represented April Gallup against Dick Cheney and Don Rumsfeld and General Richard Myers. I was called delusional by Denny Chin in the district court in New York. I was sanctioned twice by the Second Circuit, once for suggesting that the existence of John Walker on that panel was improper. Who was John Walker? He was President George Bush's first cousin once removed. And he was there along with Judge Winters and Judge Cabranes to decide whether or not President Bush's appointees had committed mass murder and treason. I was sanctioned twice, and I made a very understandable but an egregious mistake that still stands in the shadows today. And yet I've never been prouder of what I did. And I couldn't have had a greater compatriot in Dennis Cunningham, one of the great civil rights lawyers of our time, from Attica to Fred Hampton to Judy Barry and Darrell Cherney in Oakland. April Gallup was a soldier at the Pentagon, and she was there with her tiny child, went to do some last minute record checking before she delivered her child to daycare. Was the first day back after maternity leave, and she turned on her computer and the place exploded. She managed somehow to save herself and her child and help apparently other people get out onto the lawn, and she survived. She was in the way of the left wing of that 757. If in fact it did hit the Pentagon, she was in the way of that left wing. I don't know how she managed to get out of that building if that were the case, but she did. She went to the hospital and she was treated horribly by operatives from the Pentagon who tried to recruit her to a story which she could not believe. And in the weeks and months and years, actually, that went from that time, she could not conform her memory to the story that was being told in the newspapers and on television. So we filed a lawsuit on the 15th of December 2008, and we accused Dick Cheney, Donald Rumsfeld, and General Richard Myers of mass murder and treason for their complicity in these attacks. That lawsuit was dismissed by Denny Chin with more or less the following words: "It is simply not plausible that the Vice President of the United States, the Secretary of Defense, and other high government officials would commit, who would conspire to enable attacks which led to the death of 3,000 Americans." I maintain that when the judge wrote those words, he abolished the length and breadth of human history. There were three notions that I wanted to say to the Court of Appeals when I argued the appeal from the dismissal. The first was that evil exists in the world. The second was that it is attracted to power. And the third, a notion I didn't think that I would have to say to anybody who wasn't 6 years old or more or less, it has no regard for citizenship. Now, the court was perverse in its dishonesty when it dismissed the case and affirmed that dismissal. And it left out a myriad of facts, and one kernel of fact that I must now relate to you. I'm sure each one of you here knows it, but maybe there's some people out there in the cyberspace who haven't. Who was Norman Mineta? He was the Secretary of Transportation. He was the only Democrat in the cabinet. And he was in the course of a meeting with the Secretary of Transportation of Belgium, I believe at the time, when he had heard that there had been a crash into the North Tower. 15 minutes later or so at 9:03, he was told that he was wanted over the White House because the second tower had been hit. He went over there and he was directed by Richard Clark down into the POC, the Presidential Emergency Operations Center, where he was told Dick Cheney was there. He arrived in that room, and sure enough, Dick Cheney was there and giving orders. Mineta, in fact, testified to these facts before the 9/11 Commission. He was there for a very short time when he called him a young fellow in uniform, came to the door and put his head in and said, "Sir," to Vice President Cheney, "the plane is 50 miles out," and left the room. He came back in a very short time later and said, "Sir, the plane is 30 miles out," and he left the room. A short time later, he came in and he said, "Sir, the plane is 10 miles out. Do the orders still stand?" And Mineta, as he testified to the 9/11 Commission, said that Cheney whipped his neck around and said, "Of course they still stand. Have you heard anything to the contrary?" In a very short time, the Pentagon was ablaze. Now, those words appear nowhere in the decisions of Denny Chin in the district court or of the Second Circuit in the various opinions that they wrote there. They excised from history and ignored into oblivion the primary facts that we told about Dick Cheney, because there are only two possibilities about the nature of those orders, and that is the question which is on everyone's mind when they hear the story. What are the orders? Well, there's one possibility, and that is that he gave orders to have the plane shot down. If that were in fact the nature of those orders, we have 240 years of history that tell us what happens when those orders are not followed. there are investigations, there are boards of inquiry, there are courts martial. And at some point or another, there are demotions or there is prosecution and imprisonment. On that day, all of the senior members of the military in this country who had anything to do with 9/11 were promoted. And there was never a board of inquiry within the military. Never. That leaves us with one possibility, and that is that Dick Cheney gave the order to let that plane be, to stand down any defenses that might exist at the Pentagon. And that means that he gave an order one way or another. He gave an order with regard to a principal instrumentality or tool of the crime at the time and the place of that crime that resulted in the devastation that we now know about. Now, when those words and those notions were excised from history by those courts, the Second Circuit particularly, those judges shredded their oaths, threw them on the floor, and had them swept to some corner someplace. The worst judicial malfeasance that I've known of or heard of. Now, I'm sorry that I've now run to the end of my time. I've got a couple, and I make it quick. I say that mistake that I made, which was very excusable, we only charged the Pentagon in our initial complaint because we intended to amend the complaint later on to charge all of New York. When they made the motion to dismiss, we then added all of the questions about New York, 60 pages of affidavits. This is a mistake that will not happen again, and we have a plaintiff ready to go. What we need now is what Danny Sheehan has been talking about and what this group here has now created, and that is the grassroots to put together an understanding general among the population that this is an investigation which must go forward. Dick Cheney, and my cry is, don't allow this to be another JFK. These perpetrators, Cheney, Rumsfeld, Myers, and many more, but those three particularly, are alive, they're on television, and they are provably guilty. So I come as an emissary of hope now for those very reasons. Thank you very much.
Thank you, Bill.
We have Barbara left, and then
Want to go?
we're ready for the closing after that. So Barbara has. So Barbara, do you want to make some closing comments?
I know Bill wants to close really bad.
Well, we are at the end of our time, so.
It's 3 minutes, remember. Well, I had a PowerPoint that I'm going to not use because of the time constraints and because I think it's more important to bounce off what other people have said that's very important. What Bill Veal just said about what the judge said at the end of the court, that he couldn't, threw the thing out, dismissed it because he couldn't possibly entertain the possibility that the president, the vice president, the deputy chairman of the Joint Chiefs of Staff and on could possibly have attacked their own country and killed almost 3,000 of their own citizens. Well, I'm here to tell you that yesterday, and I've seen this entire proceeding online in Portland, Oregon yesterday, before flying here on the red eye, I heard Judge Imposimato, to my left here, mention that there is a legal action in Italy, as I understand it, he could correct me, against a very high-ranking former official of the United States State Department and also Special Ops and CIA Steve Piesnik, and I'm probably mispronouncing that. But believe it or not, and he identified these documents in which Steve Piesnik admitted or acknowledged that the Gladio operation, which was the Pentagon, CIA, NATO's Gladio operation that did terrorist attacks against innocent civilians throughout Europe, including in Italy, that Steve Piesnik, as I understand it, has acknowledged the NATO, US, Pentagon kidnapping and assassination of Premier Aldo Moro of Italy, which would be like the JFK assassination in this country. But I'm here to tell you that at this conference, when he said that yesterday, I've now informed Judge Imposimato that this same Steve Piesnik has gone on public television on an interview with the Alex Jones Show in 2001, stating very explicitly that he knows and is willing to name under oath to the proper legal venue the military general on then Deputy Secretary of Defense Paul Wolfowitz's military staff, who confirmed to him, Piesnik, that September 11th was a false flag attack and a Homeland Gladio operation. Quote, they ran the attacks, Wolfowitz general told Piesnik, of Wolfowitz himself, Vice President Cheney, Cheney's top national security aide, Stephen Hadley, Elliot Abrams, National Security Advisor, Condoleezza Rice, all named by name, and he says just get in touch with him when there is the appropriate legal forum. Now, this is quite a paradox here, isn't it? But I wanted to mention that. The other important thing I wanted to mention is it's a caveat. It's a red flag. It is so that we don't move forward with any illusions. The architects and engineers for 9/11 Truth, and many of us in this 9/11 Truth movement, have called for many years for a new congressional investigation. Yes, we should have one, but we need to go into this with our eyes open. I almost single-handedly, at the beginning of the stages for 7 years, brought about what amounts to a new congressional investigation of the Iran side of Iran-Contra. It was called the House October Surprise Task Force. And I'm telling you, after all of that effort and all of those years and the success of a full subpoena power House of Representatives investigation with $14 million of funding, I believe that's at the level of the 9/11 Commission, when we finally got that and the Democrats were behind it, nothing happens in Washington, Danny's right, unless it's totally politicized and one of the parties feel that they can, have some advantage over the other for doing it. But in that case, the Democrats did. They saw it as a new Watergate hearing. Well, they held the October Surprise Task Force. But what happens at the very top, Danny is right. At the very top, there's no party affiliation. At the very top, it's only nominal Republican and nominal Democrat. These are deep state operators. And what happened is that even though it was a Democratic-controlled task force on the reinvestigation of the Iran side of Iran-Contra, what they did was they brought in the ultimate nominal Democrat, but actually deep state fixer for all Republican high crimes and treasons, Representative Lee Hamilton. Lee Hamilton became the executive director, the chairman of the lead of the October Surprise Task Force, and it was completely covered up. It was completely covered up, even though it has now been confirmed and validated by formerly classified documents that have now been leaked. So I just want you to go into it with your eyes open. If we do get a new congressional investigation, I believe something very similar will happen, like the Iran-Contra case with Judge King, with Danny. They wouldn't let us win that. There are certain things that they won't let you have. And this is even bigger than that. But we've learned from those mistakes. I believe that we can move forward and we can prevail. So with that, thank you.
Thank you, Barbara.
Thank you, Barbara.
We're now actually ready to move to closing remarks.
Thank you, Barbara. Thank you, panel. And we want to thank Margaret Matz for translating for Judge Imposimato throughout this series. And now, with prematurity over, we want to thank you for your attention and forbearance and elevation in terms of what this panel and the previous panels have tried to impart to you. The great fear, of course, is that what happened in 9/11 will die, and it'll die with the people in this room when you all pass away, unless there is some grassroots legal action that can be implemented either as we have discussed with Judge Imposimato in Italy, or as Danny has mentioned, some of the options that may be available here in the United States. Representing some of the families some years ago, I surveyed the entire federal bench in this country. And I came up with 3 federal judges who were possible recipients for a civil action in this case. One of them has retired. One is still on the bench in Michigan, and the other is in Vermont. So there is a glimmer of hope, as far as I'm concerned, that maybe something can be done in the right court, but it's very slim and very small, because as they all have said here, Danny and Barbara have confirmed, it makes no difference which political party is running this country. The ruling masters dominate and have run it, and we have been on an endless war paradigm now since 2001, 9/11. Anyway, it's up to you to perpetuate this information you've gotten today. Thank you for coming. And Mick, you wanted to have something to say to your group.
Yes, and I don't, if my colleagues would humor me, I would like our guests who are not board members of the Lawyers Committee to leave the stage for a moment. I'd like to bring our board members up. I want to pose a question to them as board members. So Yvonne Bushiater, if you're here, if you would come up, Bill Jacoby. We have Dave here, Jane Clark, Mike Diamond. And Judge will excuse you. Thank you for all your assistance. And hopefully, no, he should take a seat. And I think we actually have no other burden on him for today. So who are we missing? Yvonne Bushiater, are you here?
It's right here.
Oh, I'm sorry. So we have a quorum of our board, and as we close, I just want to pose a question to the board and ask if they would vote in favor or against the approach I would like to take. And also, we'll have to get a second before we can vote. So my proposal to the board is that the board authorize the Lawyers Committee for 9/11 inquiry from today on to begin the preparation, including any necessary investigation, of civil litigation on the issues that have been discussed today, and to begin building a legal team as resources become available, and to begin soliciting those resources for that work, and parallel to authorize the preparation and filing of a request for a federal grand jury, and as we determine appropriate, a New Jersey or a New York grand jury. That's my motion. Any second?
I second that.
All in favor of the motion, raise your hand or say aye.
Aye.
Aye. Any opposed? Any opposed? None. The motion carries. Thank you all very much for coming, and we'll see what we can do going forward. Please get in touch with us if you wish to volunteer your time. If you're a lawyer, if you're a law student, if you're a scientist, and we will need some donations, please keep us in mind. Thank you.
Hello.